Any mention name?
Yes.
This matter, my lord, sir. This is the matter which was added yesterday, my lord. The jails are not recorded.
Argued on Friday. Shabdan.
Is that matter, my lord, where my lord had noted that the internet order was in operation for a long time? And
Yes, yes, that.
But our names are not recorded in the.
Yes, yes, that's right. Yes, this matter is taken up. On mentioning by learned counsel appearing for the respondents. Stop the writ petition. The order passed by us on 2nd February 2024 only records the name of learned counsel who had appeared for the petitioners, but not the names of learned counsel who had appeared for the respondents. Stop. Let the order accordingly next reflect these names for the respondents, colon. Mr. Chakraborty, please give him the list. Next, let the order be corrected to the extent as pointed out above.
Item number one, CRM DB 3 of 2024.
Applying for the petition. This particular.
अरे ये तो दो जेटा बोलम जैसे that's okay. It
I'm placing the CD, Your Lordship, by marking the role of the accused person. And I'm relying on two judgments very recently of Hon'ble Supreme Court.
Yes, sir. Show us the judgments
Yes.
first and then.
Two sets. The short notes I have mentioned, Your Lordship, paragraph 11.
Why we file notes?
Short-
Paragraph 11.
Because it's a very voluminous CD, Your Lordship. I have to take Your Lordship to the relevant page.
No, no, we remember the facts. Paragraph 11 of this judgment.
11 of first judgment, that is of Unit of India versus Ajay Kumar Singh.
Yes.
I have brought this judgment because the instances are similar in nature. Lordship will find from paragraph 11, may I read, Your Lordship?
Yes.
The information revealed by the above two accused persons indicate that both of them knew the respondent accused and that they had connived with him to transport the illicit ganja, and they were in direct contact with the respondent accused all through on his mobile number. The facts are unfurled from the complaint FIR and the statements of the above two accused persons recorded under section.
No, paragraph
60
11 is learned counsel, learned senior counsel for the submits. This is state of Kerala
No,
versus
Union of
Rajesh.
India versus Ajay Kumar Singh alias Papu.
No,
Two
then,
judgments have placed here.
the second one, very well, yes.
The facts as unfurled from the complaint slash FIR and the statements of the above two accused persons recorded under section 67 of NDPS Act reveals that respondent accused is the kingpin and the organizer of illicit trade in ganja. It is on record that the respondent accused has been involved in similar crimes in the past and that several cases are pending against him. In light of the above, the grant of bail to the above two accused persons, the driver of the vehicle and the helper, does not need to be ground and sufficient reason for granting bail to the respondent accused. The above two accused are not the main accused, but the vicarious agents of the respondent accused, who is the main person in drug trafficking and was involved in the above illegal transaction. The role of the respondent accused is clearly different from that of the driver and the helper. Why I am emphasizing on this, Your Lordship, here also there are three accused persons. One accused has already been enlarged on bail. There are two other accused persons. One among them is before Your Lordship today.
No, but you said that the accused person is, manages that plantation or something.
Yes, this.
Manages that plantation and he was, his name appeared from the statement of the person of the other accused.
Yes.
That is what you had said.
Yes,
So there are three accused, but there is only one accused before us.
all, before your lordship is only one accused.
Yes, yes, so
There are three accused all together in this
Miss,
particular case.
yes, but don't confuse the case, please. There is only one petitioner before us.
Lord.
Yes. Yes.
The co-accused Om Prakash Yadav in his affidavit filed, this is not very relevant, 14th paragraph I'm reading. This apart, it is noticed that the Honorable High Court in passing the impugned order of bail has lost sight of section 37 of NDPS Act, which inter alia provides that no person accused of an offence involving commercial quantity shall be released on bail unless the twin conditions laid down therein are satisfied. Namely, the public prosecutor has been given an opportunity to oppose the bail application. Number two, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence and that he is not likely to commit any such offence while on bail. For the sake of convenience, this has been reproduced. So I am not on that because that is there. In view of the above provisions, it is implicit that no person accused of an offence involving trade in commercial quantity of narcotics is liable to be released on bail unless the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence and that he is not likely to commit any offence while on bail. The quantity of ganja.
Miss Zinu, let us tell you this, that NDPS 37, there are views on both sides, all right?
Lordship.
There are recent judgments also of, I think, bench headed by Justice Bhatt. Then I think one by Justice Dotto, or whether it was, I think, Justice Dotto, Justice Bhatt sitting with Justice Dotto, which takes into account Article 21 of the Constitution.
Yes.
And says that you cannot be incarcerated because that's a denial of your rights, all right? So there are judgments on both
Both
sides.
sides, Lordship. But here in this judgment, State of Kerala versus Rajesh, Article 21 also has been discussed.
Very well. Any other judgment?
Yes, State of Kerala versus Rajesh. This was delivered on 24th of January 2020.
Which paragraph do you want to rely on?
Yes, I want to rely on paragraph. Paragraph 20. 21. 20, 21, 22 and 25. Lordship, we have to see the role played by this particular accused person, which I can draw your lordship to the charge sheet. What was the role played by this particular accused person?
What does 20, 21, all this say? No, don't read out, don't read out.
I'll just read one paragraph.
Look at the facts at paragraph 4, completely different. Every case will go on the facts. Cannot be a general
So we have to
proposition.
see what was the role played by this.
Very well, yes. Show us
Should
that,
we
please.
kindly come to the charge sheet, which I have flagged in.
You have in this bunch of documents.
Not of the voluminous one, the one more file I have given. Inside that,
Konta dekhachhe?
yes, which, that one. Two sets I have kept
Two
it.
sets?
Two sets. टू सेट से देखिए फ्लैट लगाया वाला दो सेट है उसमें और पेज 20 है।
Page 24.
One set of short note and two sets of documents.
This by mistake left.
Yes, yes.
Inner page 20, Your Lordship. Third
Yeah.
paragraph. From here, the offence starts. That on 13/7/2023, during PC remand, accused S. Karthik was interrogated to unearth the source and to establish entire chain of the crime and details of co-accused. During interrogation, he disclosed that he gave one packet of methamphetamine to one of his friend, namely S. Balamurgan, who is the petitioner herein, a resident of Bambanala, Sipigat, and the stuff is concealed somewhere in the Arikinet plantation of Dr. Palni, whose caretaker is the father of S. Balamurgan, situated near Invent Public School, Bambanala, and the same may be recovered on searching at the plantation. That on disclosure of suspected person S. Balamurgan, son of Shri so-and-so, was summoned to PSCCS. He was thoroughly interrogated, but he doesn't disclose anything about the contraband drug he received from the accused S. Karthik. On that, SHU CCS in order to conduct search operation at the said Arikinan plantation, where he concealed the contraband drug as disclosed by accused S. Karthik, that after obtaining necessary permission from DSP CID Shri Piyush Jain on charge of DSP CID, that a raiding team was constituted and conducted search operation in presence of suspected accused S. Balamurgan, an independent witness of
Balamurgan, who?
petitioner.
No, who is S. Balamurgan? Is
Yes.
petition. Yes.
Independent witness at
Yes.
Arikinet plantation of Dr. Palni, situated at Bambanala, Sipigad. During search operation, found one transparent polythene packet wrapped by sellotape under the garbage of Arikinet
You
tree.
know that a raiding team was constituted and independent witnesses, part of the raiding team.
Yes,
That is
in
completely
NDPS,
contrary to 41B.
Lordship, in NDPS Act, the
No. Completely contrary to 41B.
Lordship,
NDPS Act 37 we completely appreciate.
yes.
What 41B, you please read DK Basu, and there are a host of judgments. There was also a judgment passed by Justice Bagchi sitting with Justice Kapoor, relying on DK Basu. Completely contrary. What are you saying?
But these are a matter of trials, Your Lordship.
Very well. No. Yes, you can carry on, please.
Mm. The transparent polythene packet containing methamphetamine was weighed using electronic weighing machine and found to be weighing 0.739 kgs of methamphetamine. The same has been seized under cover of seizure memo in presence of independent witness. On spot interrogation, S. Balamurgan admitted that this packet was hidden by him containing methamphetamine, which was provided by his friend S. Karthik. That on confirmation of commission of offence by co-accused S. Balamurgan, he was arrested on spot under section such and such after observing all codal formalities in presence of independent witness. That on effect of arrest of one more accused person in that case and recovery of commercial quantity of methamphetamine existing under section such and such has been covered into section such and such in the instant case. That on 13/7.
And, didn't you say that the first quantity seized was below commercial quantity?
No,
That's what you
initial
said.
one. Yes.
Yes,
Huh.
I see. No,
With
no.
some other accused, not from him.
Yes, but you said the first quantity was below commercial quantity, and then later on at the subsequent rounds,
Yes,
there was more commercial
yes.
quantity.
Yes. Now, there was three recovery. Now, third one, that on 13/7/2023, the search and recovery operation was conducted at midnight, odd hours. This is very vital. Thus, whole area could not be covered up due to darkness. That in prediction of concealment of more contraband in items in the said plantation, SHO PSCCS directed the IU to conduct extensive search against the same Arikinet plantation. That a raiding team was constituted and conducted search operation in presence of suspected accused S. Balamurgan, an independent witness at Arikinet plantation of Dr. Palini, situated Bambalana, Sipigad. During search operation, found one number of black color backpack makes sky bag containing inside one number of steel tiffin box, round in shape. The tiffin box was opened and found one transparent polythene packet containing crystal-like substances. The crystal-like substance was examined by using drug detection kit and it was found to be methamphetamine. The contents were shown to the witness. The transparent polythene packet containing methamphetamine was weighed weighed using electronic weighing machine and found to be weighing 202 grams. So first recovery was 0.739 kgs and then 202 grams. So there were two occasions where two packets were recovered.
Very
So
good.
this is,
And they were recovered from the petitioner before us,
yes,
from the petitioner.
from
before us.
the, because he was present. He,
Very good. Yes, sir. What
not
did you say?
from the personal,
Lordship,
Yes.
I
but
make,
he was in conscious
But
possession of the.
What are you saying, Miss Zee? I thought, we thought you do these kinds of cases. The recovery has to be made from the person concerned, all right?
Yeah.
The police is taking the petitioner along with them to these, whatever, Arakanat plantation and all that, and going on recovering substances.
Lordship.
Yes,
Lordship. Lordship, I want to show page, I want in the charge sheet, page number 31, the Caesar memo. Caesar memo.
have you shared these decisions with him? Miss Renu? How will you distinguish? How will you distinguish today? You should have shared it, you had the weekend. Yes,
Lordship,
sorry,
my charge
sorry,
sheet, page number
name
31.
is,
My charge sheet in,
Mr. Pradeep,
yes,
yes. Page,
31, Lordship.
yes,
Lordship, this is the Caesar memo. If you wanna see, Lordship, she's, serial number 2, the time of Caesar is
yes,
21:41 hours. And I also want to show, come to the page number 129.
yes, so 21:45 hours, so then what is the
After
conclusion?
that, I want elaborate, I want to show certain document, after that I will.
Yes.
You know, Lordship, on 129 page number.
Yes,
This is the IOC is the say is a record entry. This particular property is registered one person named Chinaya. If your Lordship see the area of the hectare 0.6565. When we convert into square meter, it will around 6,500 square meter. It is a huge area. I want Lordship to come to page number 5 so that it can be clear how this case was planted upon me. Page number 5, the back end side, Lordship, the paragraph 3.
paragraph 3,
Paragraph 3.
page 5,
Uh.
the begins with that the suspect.
Yes.
Yes,
That the suspect person Balamugan was summoned at PSCCS on 3/7/23 at 800 hours. As Balamugan so and so came to the PS and he was thoroughly interrogated in the presence of Inspector D. Jagdish Rao, SHO PSCCS. But he does not disclose anything but the contraband about these contraband drugs he receives from the accused S. Karthik. On that SHOPS CCS ordered to conduct a search operation at the Akanat plantation where he has concealed the contraband drug as disclosed by S. Karthik. After obtaining necessary permission by the DSP, CID so and so, and after through the independent witness, if you wanna see after 3-4 lines, it is the timing it can see. It's about at about 20:40 hours. At about 20:40 hours, IO along with the Inspector D. Jagdishwara, along with relevant documents, investigation kit and drug detection kit and electronic weighing machine left the PS. From PSCCS is to Bambanala is around 13 kilometer. If the car rides few from here to Bambanala at the speed of 60, they reach in 20 minutes. If you want to see the code and formality that has to be followed, section 50 notice has to give to me. Once before the search conducted, my house was conducted, my personal search was conducted. I'm still not believe that how they it's a timing of 20 minutes from here to that the particular 13 kilometers. There are 3 and 4 traffic signals are there. At about or it's not an order. We can assume.
so what is the conclusion?
My conclusion is that if you want to see the timing, it is clearly shows that this particular case was planted upon because in entire if the particular area is a 6,500 square meter. It's if you want to see if you wanna see, it can be easily find out. Mm,
31, page 31 says 21:45 hours.
45 hours.
And you're saying that
That is a seizure time. Seizure time.
Caesar time.
If you wanna see.
What is this thing about
It-
20 kilometers and all that?
20 minutes. If you want to see in the paragraph, at about 21 hours, the police team reached the spots. From they starts at 20:40 hours from here. At 9 o'clock at the night, they reach the spot.
Yes.
There is that also not the spot. They reach the near the Invent Public School. After that, then there is a nearby. Before the search was conducted, my house was searched. After subsequently, my personal search was conducted. My section 50 notice was given. I'm still.
So you're saying 45 minutes is not enough for that?
It's not enough for that because it's a 13 kilometer from particular PSCCS village. PSCCS is from Bazaar. Bazaar to there because in between there are three signals.
And where are you seeing all this? That you were searched, your house was searched and all that? Which page?
Lordship, the section 50 notice can be seen.
No, where are you getting all this from? That you're.
Regarding the search of my house search was by my client, I have got instruction.
No,
And
but it must be
that is not
appeared
It's
in the
not
record.
there in the record. This is not there in the.
Yes, yes.
And regarding the search, if I'm still have to believe that the 6,500 square meter, at the help of one torchlight, they find this particular contraband, and they seize the particular. And regarding the witnesses, they not follow the code and formality of seizure 41, 42, because section 41 has a
42 says that your immediate superior has to be informed.
inform.
42, 42:1.
This particular place is not a public property. It's a private. Section 42, clause 2 has to be.
So isn't there a provision that after sunset,
Yes,
isn't
yes.
there a provision that
Yes.
section 50?
Yes. Not section 50, section 42, clause 2, there is a.
42:2,
Oh, yes.
after sunset.
After sunset, if the formality is seizure and arrest is made, they have to, within 72 hours, they have to inform to his immediate superior. That
Which
was
we
not
have
followed.
followed. Which we
It
have followed.
Not followed.
My learned brother is going into
It's
the
not
trial
followed.
now.
It's not followed. That because entire NDBS cases are reliant
So
only
is
upon.
একটা বই দাও তো? ওনাকে।
Lordship, if we see that's why it's authorized
42:2 is immediate superior,
immediate superior
but that is after sunset.
after sunset. Lordship, the before 42 true, there's a providing the such officer is reason to believe that search of warrant and authorization cannot be obtained without affording opportunity for the concealment of the evidence or the facility escape of an offender. He may be enter and search such building, conveyance and enclosed places at any time between sunset and sunrise after recording the ground of his brief, where any section after that the 42 clause 2 says that when an officer takes down an information in writing under subclause subsection 1 records grounds of his brief under proviso, he shall within 72 hours send a copy to the immediate superior as per section 42 clause 2. And why I say that, your lordship, section 41 was because I was in custody from 1800 hours. All the higher officer, IAS officer, other than police department, resident come officer here in locality, they fail to get an authorization of warrant from the. It is not like that I was in alternate plantation. I can be flee away. I can dispose of the particular contraband. It is not like that case. I was with their custody. They taken me. They taken along the witnesses. Where section they not.
Where did you find that after sunset and before sunrise?
Lordship, section 42, upper before one paragraph is.
Yes, between sunrise and. No, that is during the day, but there is another clause which says after sunset.
Yes. In between sunrise and sunset.
Yes, yes. You don't even read the section. You're arguing that that's the second proviso.
There's a second
We are
provision.
asking you, you should
Second.
be, at least know the,
I see.
the law.
Second.
That's the second proviso.
Yes.
Yes, anything else?
Lordship, and regarding the section 50 notice, I want to show the page number 34 and 35 of my charge. Page number 34 is
What is the violation under section 50? Which condition has been violated?
the condition is this is the 34 is the original notice which is issued to me, and the second 35 was received by me. If you honestly before receiving, if I can read the paragraph in English as
No, just tell us which condition has been violated.
they have
under section 50.
they have before my signature they have stated, they put a tick mark on I don't require any person can be such conduct in presence of any nearest gazetted officer. Before my receiving the copy, if you honest see that particular, I have been informed and have understood that the notice of personal search under section 50 notice of NDPS Act. After that, I required oblique, I do not require. At that, my personal search may be conducted.
Which condition has been violated?
This particular paragraph I saying because
Look at section 50 and tell us which condition has been violated.
section 50 clause 2 has been violated. Because in this page number 35, it says that after, if you wanna see both the pages, before I receive, there is a strike mark of I do not require. After that, here in my, I've received the particular document, they mention it, I don't require. There is a contrary even in the section 50 notice.
Yes, and how do you say that 52 has been violated? By page 35?
By 35.
What does 35 show?
Lordship, if see section 30, page number 34, the second paragraph in English they have written.
Yes, you have signed that you do not require.
I do not require. That is 34 is the original one.
Yes.
Before I put a signature, that is served to me. If you honestly before my signature or anything, they already put I do not require. I do not require.
How do we know that? That before
Even that is the difficult. You know, if I can understand, I can understand.
How do we know that before your signature they have ticked this do not require?
If Lordship, you see this page number 35, it was a received copy. It was a received copy. Here I don't know who is written, but my signature is present. I denied of the police.
Very well. This point will not get you anywhere because we don't have any evidence that it was your signature was put before this I do not require was put before you signed the copy. There's no evidence of that.
Lordship, my only thing is already in this case, the co-accused was charged under section 27A of NDPS Act. And he was enlarged on bail.
Show us your.
This is the certified copy. Our Honorable High Court has passed this particular. And regarding my
Accused.
is a co-accused.
Ms. Zinu said the three persons were looked up and one has been enlarged on bail.
Enlarged on bail.
You're one and who is the other?
Other is S. Karthik, who's also in the judicial custody.
This is Rajendra Singh.
Yes, Lordship. Lordship, regarding the My
That is all. Bail hearings don't go on beyond 10 minutes, and today is the
Yes.
second.
There was no
Yes.
recovery from Rajendra Singh. That was the reason. And one more thing, Your Lordship, we have found the CDR report from where it will reveal that they were in constant touch with each other, Karthik and Mr. Balamurgan.
Lordship, I'm not a friend, I'm his relative.
Very well. Now don't say all these things. Yes.
Lordship. Yes.
Yes, this is, we have heard learned counsel appearing for the petitioner and the prosecution. Stop, next, list this matter tomorrow under the heading for judgment. Huh? Have you given us copies?
Yes, I have.
That,
That can be written, that can be written and the bulky one can be written.
Yes, yes. We have produced, the case diary has been returned to the, to learned counsel appearing for the prosecution.
Item number 2, WPA 8/124.
Yes, Mr. Tabrez, airport,
That was submitted, my lord, by the.
by Mr. Chakraborty,
Yes, my
airport.
lord. And thereafter we prepared the ticket and sent it the same day in the afternoon. Then we were informed by the police authorities that they wanted to have a look at the copy of the order. Even that was then sent through the police. Then the later communication, if Mr. Chakraborty would not dispute with me, the later development was that they said, no, the parents of the
Yes.
girl, because the girl is not coming in contact, they are not allowing. Then the ticket was sent, the order of the Honorable Court was sent. Then thereafter, they changed their stance, saying that ask the petitioner to come down to Calcutta and take her. Whereas she herself came voluntarily on 21st of September alone from Calcutta to Port Blair to marry the petitioner, my lord. And initially the police had conversation with her and she said that she wants to come
Yes,
back.
Mr. Chakraborty, what is all this? Yes. We will dispose of the matter. We are not concerned with how the petitioners will come to Port Blair. The only thing is that the petitioner has been recovered, location found, and now the petitioner wants to come back. That's all.
The location has not been found. It's
The parents, that's what I'm saying.
she is not in a legal custody.
What is the purpose of a habeas corpus?
To get somebody out of the custody. If he or she is in an illegal custody.
Application is also unknown, basically to produce the
Yes.
body.
Yes,
That's the purpose of a habeas corpus.
yes, my lord.
Here, the only squabble now is, a conflict now is whether the petitioner will travel on her own.
No.
Or the parents will provide for that.
These are the grounds that are being made out by the parents. Now, the wife is being held up there against her will.
Very well, Mr. Chakraborty, what do you have to say?
My lords, the police can be directed to produce her in court, my lords. Definitely, so far as this change in stand is concerned, there is no disputing that because now the
Change in stand as in the parents saying that.
now the parents and relatives saying that she can't be left alone and this and that, and what if she gets lost in the airport? These kind of things are being said. So, my lord, she can be produced, my lords, in court, and then my lord can, after that, my lords, dispose of her.
My colleague is suggesting, what about a video conference conferencing with the parents? Is that possible?
As my lord's desire. But
Yes, yes, as well as the, the petitioner's wife.
My lord.
The lady
My
concerned.
lord, the appropriate would be that pressure would be there. The appropriate would be if she's produced and my lordships may interact with her and find out her wishes and what has happened. Possibly what will be.
Once she's produced, what remains? Why should we find out? Are we interested to find out what's going on?
Well, look, if video conferencing is definitely a possible way, but we can't rule out the fact that once she is made to interact through a video conference, that the pressure and the force would continue to remain there.
Yes, from the submissions made on behalf of the parties, comma, it now appears that the parents of the wife of the writ petitioner are refusing to arrange for the travel, arrange for their daughters' travel to Port Blair. Stop. The court is informed, we are informed that the parents now insist that the petitioner should go to Kolkata and bring his wife back to the islands. Stop, capital I. Stop, to the Andamans. Stop. Next, considering the change, the frequent change in stand of the parties in the present matter, comma, we deem it fit to direct which police authority will be the correct one?
Number one, SHOPS.
The SHO. Respondent number 1/SHO, comma, PS Aberdeen, comma, Port Blair, to produce Miss, just check the spelling, Tiasa Biswas / Miss Aisha. On what is a good date, Mr. Tabriz? How much time should we give?
Friday.
Friday. On today's
Thursday
Thursday is better. Friday, yes.
will be running to the end of this.
Yes, yes. On the February, on 8th February 2024. Stop. Next list is matter on that date.
Apply.
Item number 3, WPCT 9 of 2024.
My lordship, my senior Mrs. Anjali Nag is appearing on behalf of the petitioner, my lordship. Service upon the private respondent is incomplete, your lordship. So let the matter may be taken in the next circuit.
And the order should be for, not FRO. Adjournment is paid for on behalf of the petitioner and counsel appearing for the petitioner on the ground that service is not complete. Stop.
I am appearing for the state respondent.
You are the counsel in the matter.
Yes,
Learned counsel, comma, who seeks the adjournment, comma, also prays that the matter be placed before the next circuit bench. Stop. Next, let the matter accordingly be placed before the next circuit bench.
much obliged.
Item number 4, WPCT 11 of 2024.
My lord, I am for the petition. My lord,
Yes,
inadvertently, in the presentation form, it was mentioned as today's date.
yes.
But despite notice was served on the respondent that it will appear on 8th. This is inadvertently, it is done, let this matter be taken up on 8th.
I'm appearing for the respondent.
Yes, learned counsel opinion for the petitioner seeks that the matter be taken up on 8th February 2024, which was the date mentioned in the notices sent to the respondents. Stop. Next, list this matter on 8th February 2024.
Item number 5, WPC 73 of 2023.
Your Lordship, my senior Mrs. Anjali Nagi is appearing on behalf of the petitioner, Your Lordship. Today we are filing the affidavit in reply and serving the copy to the opposition party, Your Lordship.
Are you out of time?
No, Your Lordship, let the matter may be taken in the next date, Your Lordship, because
Next week?
next day, next circuit, Your Lordship.
Why next circuit? You're filing your reply today. Why next circuit?
Your Lordship, let the matter may be taken in the next week.
Next week? Tomorrow? Mr. Chakraborty, how much time will it take to read the reply?
Because it can be taken up tomorrow, I don't know.
Okay, Your Lordship.
I am appearing for the private.
Yes, the affidavit, the petitioner's affidavit in reply is taken on record. Stop. List this matter tomorrow.
Item number 6, APT 5 of 2023.
Council Vijay Kumar is appearing.
Come here, come in front and go submission, please.
Learned counsel K. Vijay Kumar is appearing in this matter. He has been to Chennai for his medical treatment. He is returning today. Let this matter be.
I am appearing for the respondent after service. I find that the no
Respondent as in the private respondent?
private respondent.
Yes.
It's a matrimonial suit.
Yes, yes.
Copies, section 5, 3, 4 annexures are there. Nothing has been enclosed with the petition. I will file reply because there is a delay of more than 83 days of the section 5. Nothing, complete application has not been
Yes,
provided.
why is it that? Why have you not given the complete application? Without annexures you have given.
I'm not the counsel. No, this is I'm just on behalf of Mr. Vijay Kumar, I'm submitting.
I will file opposition, let the supply complete in the.
Learned counsel appearing for the respondent submits that the respondent has not been served with a complete application. Stop. Next, list this matter tomorrow. The petition, petitioner is to a complete application shall be filed on the respondent in the course of the day.
Item number 7, review all of 2024.
Because in that habeas corpus matter. ठीक है sir. My lords, in that habeas corpus matter, actually, they have to process it with the department to get the ticket. My lords, I know, my lords, it is usually uploaded the same day, but my lords, some precedents.
Yes, yes, we ordered আমাদের তাড়াতাড়ি করে দিতে বলে আমরা যখন দিব তখন সাইন করব।
The review application, my lord, both the honorable judges are
Not there,
there.
are there?
Yes.
Where is the order? Which is the page?
My lords, actually, I don't have a copy of it. Justice bench presided by Justice Showmanson. And Justice Shampada for
Siddhartha Roy Choudhury.
Siddhartha Roy Choudhury.
If you say Miss Dutt Paul, then both of them are there.
My lord. Justice Siddhartha Roy Choudhury is
Yes.
retired. sir. My lord.
The review, the review application pertains to an order passed by a division bench on 16 November 2023. Stop. We note from the order that one of the honorable judges is still present, is still available. Stop. Next, Chief Justice. Hence, next, hence, comma, we request the Honorable Chief Justice to assign the matter before an appropriate bench. Assign this review application before an appropriate bench. Stop. What is CAN 1?
List. So before condemnation.
There is a delay. CAN 1 of 2024 is an application for condonation of the delay of 27 days in preferring the review application.
Item number 8. Deputy on of 2024.
Your Lordship, I senior Mrs. Anjali Nag is appearing on behalf of the appellant, Your Lordship. Let the matter may be fixed not today, Your Lordship, because she is engaged in another court, Your Lordship.
The other court is also sitting here. What other court?
I think in CAT, Your Lordship. She's in CAT, Your Lordship.
Yes, adjournment is paid for on behalf of counsel appearing for the petitioner. It is 8 or 9? 8? For the petitioner, stop. List this matter tomorrow.
Item number 9. Mrs. Maya 2024.
Your Lordship, in this matter also, Mrs. Nag is appearing on behalf of the appellant. Let the matter may be fixed not today.
This is on that, my lord, the issue of jurisdiction, whether my lord, the cat will hear.
Yes. That's right.
Was served with a copy, incomplete,
Incomplete.
incomplete. Only written application copy has been provided,
You are appearing for the Union of India?
my lord.
The scheme is of the Union of India. So
Yes. When do we keep this? All matters of Ms. Nag are going tomorrow. Yes, when should we keep this, Ms. Chokpati, tomorrow?
well, it's tomorrow. If not tomorrow, then on 8th, my.
No, we will keep it tomorrow, then let us see. Because we can't keep on postponing matters. Yes, same order. Adjournment is paid for on behalf of counsel appearing for the petitioner. Stop. This matter tomorrow. Stop. Learned counsel appearing for the Union of India submits that an incomplete copy of the writ petition has been served upon him. Stop. Next, let a copy of the complete writ petition be served on counsel in the course of the day.
Item number 10. We are reading on of 2023.
I again carry to file for the case.
Mr. Kabir, you finish in 10 minutes, all right?
My lord, to make it simpler, as I had stated earlier, I'll just give your lordships a short précis of the matter. Copies have been given to Mr. Binnu and Mr. Tabriz for the accused. So if I may place it from here. First of all, I have just indicated out of all the witnesses, who are the main witnesses who contribute to the creation of the circumstances. Thereafter, I've laid out the circumstances which I had pointed out. Even if the eyewitness is not being believed, then the circumstantial chain which is created. The first circumstance is the genesis and the altercation that happened. There, I have indicated the witnesses who have spoken of it together with the page number of the paper book. The second thing is that the genesis and altercation is being admitted by the accused persons in their
Mr. Kabir, sorry to interrupt you.
Madam.
What you want us to do is that these two accused persons, they have been acquitted
Madam.
by the impugned order. So you want us to reverse that impugned order, which
Madam.
means that we put these two persons back in jail. That is what you want us to do.
Madam, that is, there are two alternatives. In terms of 386, the powers of the court are either to remand this matter back for a consideration on all these points, which has not happened, or a court in reversal may reappreciate the evidence, see where the prejudice has been caused, if there is a perversity in the court's order, and then in that case, the court may apply its own mind independently and pass an order of conviction. These are the two.
No, pass an order of conviction means put them back in jail.
Find them guilty of the charge that
Yes,
was
yes, of
framed,
course.
and
We
then
can't put them
as a
back in jail
corollary,
because
they go
they're
back.
hearing the matter. Yes,
As a corollary, they go back.
very well. So you realize we have no doubt as to what we have to do, but the only reason why we put that question to you is that you have a very high threshold to cross.
Madam, that's threshold, in order to cross that threshold, the test that is laid down by the Supreme Court is that once there has been an acquittal, the presumption of innocence is further strengthened.
Yes.
So there has to be a perversity demonstrated where the court has not considered something or the court has ignored something. That is a case I have made out. I have indicated the 13 or 14 circumstances that were made out. And I have indicated the page and the paragraph in the judgment where the court has simply ignored those. The fact
So the
that
perversity is that the evidence was there, but the evidence was not considered. Not that some other extra evidence was considered which was not relevant,
the judgment itself has sought to sum everything up in about 5 or 6 paragraphs. If your lordship just takes my note, I have pointed that out as well. Page 7, this is circumstance 16. Or point number 16, Roman 16, page 7. I have highlighted 6 points. The 6 things that the court discussed while passing the order of acquittal. And I have given my answers to them. So the first is between paragraph 62 and 67, the court dealt with the issue of non-examination of the IO. I have given my answers to those thereafter. The second thing is at paragraph 68, where the court.
So non-examination of IO is the reality. You are saying that the IO was not examined.
The IO was not examined because the IO had emigrated from India and gone off to Australia. Now it is their case that for 2 years, this court was trying to get him back. It is my case, based on the records, which I've also mentioned, that the court did not make an attempt to get him back. The court was simply passing orders to next date for examination of other witnesses, including the IO. That's all. The first that this entire incident came to the light of the court's notice was by a petition being made, which said that this particular IO has gone off to Australia. Please give us some time. My lord will get that as well. The dates.
And you're saying that the IO's presence was necessary to the extent that if the IO had been examined, then the case would have
No, I'm
turned?
not. I'm saying that the proposition of law, which is accepted proposition that the non-examination of the IO is not fatal to the prosecution case.
Yes.
Now, the court here has not gone into this question at all. The court has simply said because the IO was not examined, so we discard PW9. Now, this proposition is an incorrect proposition. A
PW9 is the IO.
is the eyewitness.
Eyewitness.
Now, the 2 mistakes the court made here, the first was that by discarding PW9 as a whole, the court went on an erroneous trend. What the court ought to have done is to establish the degree of prejudice being caused to the accused persons through the non-examination of the IO. Now, assuming that that eyewitness went, the second mistake of the court was to believe that this case is based entirely on that eyewitness. Even if I ignored the eyewitness, the court had to look at those 13 circumstances and come to a conclusion that fine, let me say that because I couldn't get the IO, because I didn't rely on the eyewitness, so I mean, excluding that part from the case, but still the rest of the circumstances had to be discussed. The court did not do it. There is not a word about it. And so far as the dates are concerned, if your lordship comes to page 5 of my note,
Yes.
I said at the beginning that there is a set of systematic delays. I have culled out the dates which are reflected in the LCR.
Systematic or systemic?
Systemic would be based on the system. Systematic is something which was designed and planned. I said systematic.
Yes.
Now, if your lordship sees throughout all the dates, at page 6, the first date which is relevant is Roman 38, 23rd March 2021. Now, this was after COVID. Prior to COVID, there was no mention of the IO's absence, gone to Australia, nothing. After COVID, the defense made a prayer, but they also didn't mention Tarsim Singh. Tarsim Singh did not come into the picture anywhere.
Tarsim is the IO.
Is the IO. Did not come to the picture anywhere, though there were discussions saying, please call for the witnesses, including the IO. The first time that there's an official petition is on the 24th of June, 2022. On the 24th of June, the prosecution says the IO has left India. He's coming back in March. Please adjourn the matter. When he comes, he can be examined. The court refuses and says we are going straight to 313. My humble submission was the court had options. If the court felt that it was so vital to look at the situation, he could have been examined over video conference or something of that sort. The point is that the court had closed its mind entirely. And then the court says, since the IO is not there, we discard PW9, nothing remains of the case. What about the rest of the circumstances? Those were not considered. And that part of it again deals with the situation in the judgment itself. If your lordship comes back to page 7, point number B, para 68, the court is
One minute, Mr. Kabir.
My lord.
So, this delay, that is at page 5, the point which you have taken,
my lord.
the delay goes to what? How does the delay help your case?
There are two issues of delay here. The first issue of delay is the one which I'm raising, where I say that Rajesh was a key witness. The people who were changing a tire, there were 5 of them. There were several other key witnesses. There were a number of witnesses throughout this trial who either died or could not be brought before the court simply because of the fact that years passed at a stretch. Now, these witnesses, assuming they were brought in and assuming they said anything, it might have had a different complexion on the case. My submission is that the police at the investigative stage, at the prosecution stage, were leaning in favor of the accused. That there was a prejudice that the victim, the complainant, whatever the cause of justice was, suffered. Now here, if this, I'm not saying that if this trial had happened in a year, the result may have been different. What I am saying is that if this delay had not happened, these 7 or 8 witnesses who died, key witnesses, could have come and deposed before the court. This is one. No, there are several others. Sibu Munda, PW23, was the person who was repairing his tire.
Have you given a list of the witnesses who were not examined?
Only one.
My lord, I have mentioned at point number 35 in the dates, the petitions that were filed by the prosecution 30th of August 2019.
No, you say several witnesses death reports called for. So how many witnesses?
My lord, I have seen about 6.
6.
6.
No, but where do we get that from?
From the record, from this particular record in the LCR, it shows. On that day.
There were 6 witnesses.
There were 6
No, but Mr. Kabir,
I'll add it in.
at least from which date to which date? Because if you're saying that 6 witnesses had they been examined,
My lord,
the complexion of the case would have changed, and you will have to say.
my lord, I'll add the names in. The
Yes.
situation here is this is one delay. The other delay angle is the one that my learned friends are talking about. They are saying that there was a delay after which this case took shape. So the incident happened in 2007. But till 2008, these people were not arrested and the case was not moving smoothly. My answer to that, and this is actually the main issue here, is that the delay happened because of misdirection. There were 4 suspects. These 4 suspects, 2 of them were from the witnesses' side, 2 of them were from the police side. If your lordship comes back to the dates again, I have explained that delay. So the incident has happened 27th of July 27. Thereafter, 2 months after that, the police write a letter and file a petition in the court saying we are getting no clear direction of investigation. We want to do these forensic tests, the detection of deception tests. That is polygraph, narco analysis, P300. That is placed before the court for consent on the 16th of October 2007. The accused persons give their consent and the witnesses give their consent. They are forwarded for the tests in November. At the end of November, the court asks the police, what is going on? The police files a report saying the tests are done, we are waiting for the reports. The reports come back in May 2008. Immediately, these people are arrested and immediately the petition is filed before the court with the reports of the forensics saying that we have now got some clear direction. And from there, they start their investigation. So the delay that had happened was not a delay simply because the police were creating a case. The delay happened because the police initially did not know which way to go, because these two accused persons deliberately misdirected the police themselves.
Yes, but that's your addition, Mr. Kabir. You have to see it from the records and whether they were not arrested because they were misdirecting the police.
That is the record I have shown, Your Lordship. The petitions that have been filed, which I have mentioned, which were brought to the attention of the court below, saying that these people have not given us a proper picture. The GD entries which are exhibited, which I showed, were deliberately they did not mention. The fact that when they went to the police station, there were other officers present. Those officers were examined. Those officers also clarified the situation that these people did not give this description. It was not entered in the records. This entire incident that took place was simply brushed under the carpet. So
Yes.
these two issues of delay form two different arguments. My submission remains the same thing. In all of these circumstances, the court was duty bound to look at each circumstance as it stood. Let us accept all the defects. Let us say that the delay happened, IO couldn't come. All of this I accept all to be true. But the circumstances as they stand, that needed to be looked at. That was never done.
Yes. What is the other perversity?
Madam, if Your Lordship comes back to page 7, now there are these 6 things that are dealt with by the court, only 6. The first is non-examination of the IO. The second is site
No,
plan.
so these were dealt with by the court.
These were the things that the court dealt with.
No, because we thought that non-examination of IO is your point.
No, I'm talking about what the court has dealt with.
Very well. So the court dealt with these
The
points.
court dealt with non-examination of the IO and said because of non-examination of the IO, I am not going to look into the evidence of PW9.
Yes.
Now, these A to F are the paragraphs in the judgment where the court has made these statements. My points are below that, where I have just explained my argument.
Yes.
The second thing the court deals with is the site plan. The court says that the site plan shows only the place of recovery of the body. It doesn't show anything about waves, the coconut plantation, the beach, etc. The answer to this was very simple. The body was recovered, but no one knew about the incident of the night before. So when the site plan was created based on finding of the body, not based on the incident of last night, which transpired subsequently. This either way had no bearing on the case. Because the person who went and made the site map made it based on the recovery of the body, not on the place of occurrence or the scene of crime. Thereafter, the third issue dealt with is the entire polygraph, etc. Now, this part, I am at one with Mr. Tabriz. These are not substantive evidences, but they do corroborate, they do show conduct, and they can be used to support the circumstances that are there. Now, this entire thing, the court simply says, the report doesn't talk about how the signs are measured, and so I can't accept it. And he ignores the entire thing.
But that is the right.
No, madam, with the greatest of respect, if one goes through the evidence here, the evidence
A
of the
polygraph test will at best show that a person has not told the truth.
excellent.
But would that mean that the person is liable for conviction?
My lord, the polygraph report cannot be thrown aside because the court says it does not mention how the signs are measured.
So what signs?
I don't understand. The polygraph test is meant for a doctor administering the test to see the physiological changes when questions are put.
Yes.
Now, the doctor has described that in detail in her evidence, VW21. She's gone into huge scientific detail because she was cross-examined at length. The court has ignored it, and the court says no signs shown. I do not understand what it is.
Yes.
Thereafter, brain mapping, the next paragraph, para 73, the court is simply saying brain mapping has been done, not considered. Now, my point is very simple. One is not saying this is substantive evidence, but one is saying that the mapping that was done, which showed certain patterns, certain things, this was part of the conduct. This was something which, in the opinion of the expert, formed the circumstance. Why? Because they had made out a certain story, which subsequently is shown in this mechanism not to be accurate. So I'm not going on what they said during the test. I am going on the conduct aspect, that they are found to be speaking in a manner which is not reliable, which cannot be given veracity. And that is why that circumstance, when you look at it in a larger picture, that they did not make GD entries. They did not tell anyone about the incident of the night before. They misdescribed the incident as just a local drunk being picked up. These things, read with the subterfuge that they did not guide the police to a proper conclusion, they suppress that incident. Then when they go for this test, only then all these things, they are indicating through their bodily responses that what they're saying is not the truth. This is part of conduct. So this forms a circumstance by itself. It is not a facting issue. But the conduct is a relevant fact that people who had nothing to hide behaved in a manner which was detected by these tests. So the test is not a substantive piece of evidence. But the report of the expert or finding that these people are lying is something which forms part of the chain. The court has not even said yes, no, indifferent. The court has simply talked about brain mapping one paragraph and left it at that. Thereafter, E. The court talks about 5 witnesses who claim themselves to be eyewitnesses. And the court says that we can't believe them. Who are these 5 witnesses? The last seen together witnesses, the drinking group. The court misdirected itself completely into feeling that there are eyewitnesses who have said nothing, hence I will acquit. It was no one's case that they were eyewitnesses.
No, so PW9, according to you, there were.
Only he was an eyewitness.
Very well. So that is the conclusion of the court, or that is the court?
Since 5 eyewitnesses have said nothing. There were never 5 eyewitnesses. There was only one. The other 4 were the last seen together witnesses. PW3 and 5, I think, were part of the drinking group. There was one manager from Waves restaurant, and there was one more independent person.
So you're saying that only PW9 was the eyewitness?
Yes.
The 4 others were not?
That was the case. There was no doubt about it.
Yes.
The others were last seen together. They saw the genesis. They saw the altercation, abusing, pushing, chasing into the bamboo grove. That was the end of it. They did not see an incident. So even if I were to leave aside PW9, these other 4 witnesses prove circumstances. And very inexplicably, if your lordship sees, these circumstances have to be put to the accused in 313. They were put to them. If your lordship goes to the answers in 313, it's very, very strange. Certain circumstances with regard to the genesis, the altercation, they've admitted it. And certain circumstances, our Havladar says, Jose did these things. Jose says, I never did these things.
Jose is the one which.
Jose is one of them. Havladar is the other one of them.
Yes.
Now, certain
And Rajesh died.
No, Anil died.
Anil, no. Anil is a deceased and somebody died.
Rajesh is the witness who died.
Yes.
And the other 2 witnesses are Satinder and Dheeraj, PW3 and 4.
Yes.
Now, the situation here was peculiar because when the circumstances are put to them, I can understand a witness, an accused in 313 usually says Janina, false, or whatever. He doesn't go to volunteer information. Here, sometimes the information they volunteered is contradictory. Sometimes they just admitted the circumstance. So, if the 313 is looked at, I've made a quick table of that, which is at page 4. I've given the question number, what the question was about, what Jose said, what Havladar said. So when this is looked at, together with the circumstances, it was incumbent on the court to look at all of this. However, the court does not apply its mind because it simply says 5 eyewitnesses were there. We can't rely on them. I'm acquitting. The court never appreciated the actual matrix, factual and evidentiary matrix of the matter. Thereafter, the 6th point, F. There are just 4 paragraphs. The court ignores the circumstances of the case while saying why the people need to be acquitted. There is not a whisper of the circumstances. I have not mentioned what the court said because the court said nothing. Not one of the circumstances was described or even recorded.
Yes.
And again, the misappropriation here is the autopsy report, the inquest report, the photographs that were exhibited, the entire picture of the injuries is reduced to one very absurd proposition. One of these witnesses had said at the time of chasing, one of the policemen threw a stick. The court has gone and fastened on that and said that it's only said he threw a stick. There's no description of whether the stick actually hit him. Therefore, it can't be one. The massive injuries that were there on record Had nothing to do with throwing of a stick. The court has instead gone on that path.
And what is the discussion given on that hit by a blunt weapon and all
Nothing,
that?
nothing.
The records which you placed on the last day?
The court is
The
silent.
medical examination
The
of.
judgment is silent, madam. That is why I said this order is a perverse order. If nothing else, the court has to reconsider the circumstances in their proper light. There is a certain format we come to expect. PW1 said this, 2 said this, 3 said this, but then there has to be a discussion of that.
Yes, just show us what will be the relevant section? 389,
Of the CRPC, 386.
386. Yes.
If I'm not wrong. No, I'm not wrong. 386. After perusing such record and hearing the appellant or his pleader if he appears and the public prosecutor if he appears, and in case of an appeal under section 377 or 378, this is where we come in. The accused if he appears, the appellate court may, if it considers that there is no sufficient ground for interfering, dismiss the appeal, or may, A, in an appeal from an order of acquittal, reverse such order and direct that further inquiry be made, or the accused be retried or committed for trial as the case may be, or find him guilty and pass sentence on him according to law. This 386A is where I come in. Now, the problem here is what I had pointed out to your lordships in the beginning is that this was a case of murder. The FIR and the charge sheet, every place in the record said 302. But for some reason, I am unable to fathom and I cannot submit about. The prosecution is asked to put in a draft charge, and they put in a draft charge only of 304. And the court accepts it and frames charge under 304. There is no description in the records, although I've heard outside the court from my learned friends also, they were part of the trial and I defer to their knowledge because they were there and I wasn't. That there was a lot of detailed discussion about it, but the records are silent. If the court wanted to justify reading down an accused to 304, I could have understood in fact why he did it.
So reverse such order and direct further inquiry be made.
Madam.
That is where we direct the trial court to rehear and reconsider whatever.
Yes, so there can be two things here.
Or that the accused be retried.
Retried means
Or
framing of
committed-
charge.
So what is the difference between the first part and the second part?
The first part is wherein further inquiry is to be made is when any more evidence needs to come on record. So
Yes.
where the trial is not being restarted de novo. There is a further process of calling some witness or like if your lordship says, do the IO over video conference, then that is further inquiry. But a retrial means inherently a de novo situation, which means that you have to reframe a charge. So today, if this court says that, look, 304 is not adequate, it should have been 302, it is not explained why 304 was there, then a new charge has to be framed.
So our or I don't want to use the word conviction, our opinion that the second should be relevant, that is the accused should be retried or recommitted, that would be on a
Much higher.
much higher opinion that there is something wrong with the
Much higher.
judgment.
That there's something wrong from the very inception of the case.
Well, and if if we do the first, then we feel that there is a certain amount of perversity.
This court will not prejudice anyone. This court will say that the judgment is silence on certain issues. There is there is no adequate discussion of the material that has come on record. In our opinion, this matter needs to be considered in light of the evidence on record with a full discussion on what transpired and an order be passed in accordance with law. In which case, this goes back to the stage of arguments. 313 is done, everything is done.
And the third part,
The session
Finding
here,
guilty.
arguments are fresh and passes a new judgment.
yes, and the third part is when we say that, no, we will hear all the evidence. and-
Just that we've seen the matter, we've seen the evidence. We are of the opinion that the offence is made out and the trial court was in error and hence we are passing this judgment. And the fourth part, which is in my submission, is the retrial part of it. If your lordship goes through the LCR, your lordship will find, I have never seen in so many years, a draft charge by the prosecution watering down an offence. The prosecution starts with 302, ends with 302, even the records all say 302, but the draft charge is 304. If the court read it down, I know why they read it down. The legal reason. The reason would have been that we were police officers in uniform, we were on duty, This man abused us, pushed one of us, so we acted in self-defense. So you read it down, you use one of the exceptions saying that we had
Read down which provision?
the offense. If it is murder, it can come down to culpable homicide based on the exceptions. Now, what are the exceptions? Some of them can be that I was acting under powers of law, but I exceeded it. Some of them can be private defense, that he attacked me, so I responded. All these defenses will read it down from 302 to 304. So it is conceivable that these things were in the court's mind, that these were police officers, they're not murderers. They were over enthusiastic. So let's not make it murder where the sentence is only life or death. Let's make it culpable homicide not amounting to murder, where it can be life or it can be may extend. So you have that sort of flexibility in sentencing them. So all these things could have been in the mind of the court. But the question here is, why should we be sitting here and surmising what it should have been? The court had to record these things. There's nothing. Simply nothing.
Very well. Mr. Kabir, anything else?
No, in addition to this, my lord, I have also placed certain judgments to be very candid. These are at page 8. I will make a compilation and submit them if it so commends to this court. These judgments are on certain specific principles, which my submission is I've tried to make it a very fair perspective, because most of these principles are principles which don't go on the facts. They are principles of law. So the facts, one way or the other, will support that side or support this side.
So the first one is on 386.
The first one is the reversal of acquittal, the principle that once there has been an acquittal by the trial court,
Then
and the High Court is
presumed innocent.
that
Innocent.
double presumption of innocence, and then that you have to surmount that hurdle of showing that there has been a perversity or there is something which has not been considered. So Magajavi is actually the parent judgment for reversals. Thereafter, Chandel and Siju Kurian, one will go in my favor, one will go in Mr. Tabrez's favor.
Yes. You don't know which one will go in your favor.
I know both which will go in my favor.
Yes.
The thing is that, to be very honest, like I said, these are principles of law, my lord. Depending on the facts, it will flip one way or the other. But Chandel is one of the latest, which has given the entire evolution of the law. So rather than talking about 50 judgments, I'm just showing Chandel because that shows how the law regarding reversals has come. So, for example, let us assume today, if your lordships were to theoretically convict this man, that becomes a judgment of reversal. And SLP against this order would be automatically admitted. Because the minute there has been a reversal, the presumption comes that one court applied its mind in one way, one court applied its mind in the other way. So the proposition here which Mr. Tabrez will say is, effectively, Chandel says that you are here to look at the situation from the evidence that is there. If the trial court took a view that was possible, then don't interfere. Because there can always be two views possible, and the principle of jurisprudence in criminal
So
jurisprudence.
if we were to say that we are reversing the trial court's judgment, then our view has to be that the trial court's judgment was impossible.
That the trial court's judgment was incorrect because it did not examine the materials that needed to be examined.
Yes.
But here, what I'm saying again is that if there are two views and the trial court, let us say the trial court had considered whatever I have submitted.
Yes.
And come to a finding that yes, this is there, but I don't agree. In that case, this court could have said that, well, this is one possible view the trial court has taken. We are not going to interfere with it. But here the trial court has not taken a view, and the points that they've noted are inherently incorrect. So therefore, Chandel will operate that way. And Siju Korean, the problem here is that if there was a presumption of innocence, if that innocence was strengthened further, and if I could not cross that hurdle, then the court will say there's no reason for us to put these people to the torture of another trial and or whatever. Why should we interfere at that stage if the perversity doesn't exist?
Very well. Satish is on delay.
Satish is the delay in examining of witnesses. The issue that my learned friends have raised, that initially the investigation went nowhere. They took their own time. Then they came up with PW9 after a few months or years. He came up with a version which he hadn't told before. Although this is again connected to the deaths of the people. He had told various people, but all those people died during the trial. So they couldn't come and say, yes, he told us. So that sort of situation with the delay, even the 164 statements of PW3, 4 and Rajesh were recorded after the polygraph test came. So there's a gap of time for the entire investigation. That cannot be doubted.
Yes.
But if there is an explanation for that delay, given either by the police or which is appearing from the records, which will be a systemic delay, then in that case, this court may come to the opinion that such delay has not prejudiced anyone. And that systemic delay is appearing from the records. I have highlighted in the LCR exhibit B, the B file, B1 file and C file, CGM's files and sessions files, where which petition was filed by whom showing what. Thereafter, Mir Muhammad Umar is 106. This is established proposition that once I make out a prima facie case, then the burden shifts to them.
That's not 105, that's
106,
106.
special knowledge.
The shifting of the burden.
There, again, Mir Muhammad Umar is a fair judgment because it talks about two situations. One is a closed room, one is an open room. So in a closed room, husband and wife are living together. The wife dies mysteriously. Husband says, I don't know what happened. But because it's a closed room, you are the only one who could have special knowledge. The other one is in a more public situation, like the one we have. Let us say no one else had access at that point of time. It would be for them to make out a defense case that someone else could have done something, that this had another cause, which was not the situation.
Well, yes.
Then next is Kotharkar. This is where the IO is not examined. This is an established proposition. Again, it doesn't really help either of us. Non-examination of the IO will not be fatal to the prosecution case. The defense can show a burden, discharge a burden of showing a prejudice that because my IO was not examined, therefore I could not bring certain materials on record. In this case, the ideal argument would be to say PW9 did not say all these things. Now here I have another set of submissions. PW9 is a saga which I'm having difficulty understanding. PW9, when he came and made his statements and he had to be cross-examined, the defense takes out an application before the court below saying this man expunges evidence. He can't be relied on. This is procedure unknown to law. If a person is lying, this person is to be cross-examined. You cross-examine him as much as you want to show, to shake, to demonstrate that this witness can't be relied on. In this case, what happened with PW9 was that he was initially examined as a witness in court. If your lordship comes back to the dates, page 6, Roman 18. On the 12th of August 2013, PW 7, 8 and 9 were examined. On the 9th of July 2014, PW9's expunging petition made by them is dismissed. So 1 year has passed. For 1 year, the trial was stalled because the defense filed an application saying expunge his evidence, he's a liar, and proceed against him for perjury. These are things which have to come later. At that stage, you have to cross-examine. Thereafter, he is examined after a gap of about 3 years on the 17th of March 2016. This is completely inexplicable. And he is finally examined and completed on the 6th of December 2016. So this one witness PW9 has spanned 3.5 years. God knows what happened to the witness during that time.
So there was a revisional application pending before the High Court.
Okay, I was unaware of that. Now let us assume revisional application.
So Mr. Kabir, so Kotharkar will not help you really because it says that non-examination will not be fatal.
No, non-examination will not be fatal. Helps me. I'm the prosecution right now.
Yes.
Acha, Selvi is the principles of detection of deception. These are again not in question because Selvi says very clearly these are admissible provided they are voluntary. Their consent has been recorded in a petition which I have already indicated the page. Here, if there was an involuntary aspect, that would have been an academic argument. It's not there. So this material is admissible, but to what extent? Selvi says you can't use it. It's not admissible as substantive evidence. You can use it as corroborative evidence with the other circumstances. So to that extent, this evidence of the polygraph and all, one cannot read it to see that in the P300, in the trance, he actually said, I went and I hit him so many times and killed him. Because that is in the report. One can't see that. One can see the report's finding that it appears to us that this man has a knowledge about this incident, which is more than his letting. Thereafter, Harinder Singh is where the accused has deliberately misdirected the police with a view to saving himself and implicating someone else. In this case, these accused persons, when the first point of time when they had to put everything down in black and white was when they returned to the police station and made their GDs. The GD talks about a different story. And thereafter, nothing came in the GD, nothing came out from any of these people till the polygraph test and all those tests, where in a trance he described the entire murder. And then the police gets activated into saying, okay, now we'll start investigating. And they start investigating. They couldn't do it before because Satinder and Dheeraj and Rajesh were prime suspects. The ones who were the witnesses to the last scene together and everything else were prime suspects themselves. So when that detection of deception test showed, no, these people are telling the truth and these people are lying, at that point of time, the police goes on that path, which involves taking PW 3, 4 and Rajesh to the magistrate, taking 164 statements, and then the whole case comes out. That's where that delay happened. Now, when that case came out, 164 statement of Satinder is proved and he's been examined as PW 3. Dheeraj is examined as PW 4, Rajesh died. So that is where that divergence happens. So here, this entire misdirection that happened, and it's not that they're strangers to the police. They're police personnel themselves. A body has been found. People are going around in circles trying to find out what has happened. And these two are quiet.
Very well. Next one.
Thereafter, Kuldeep. This is where circumstances are put to the accused in 313 and they give answers which are later found to be patently untrue, or they give answers which are contradictory with accepted facts or proved facts. In this situation, if the 313 is looked at where they are contradicting each other about a particular incident. So, for example, George says, yes, I was pushed and I fell down. The other man says, yes, he was pushed and he fell down. But the next circumstance that is pushed, that is given, George denies it, because if he allows an acceptance of that, he implicates himself. So he denies it, but Hon'ble is not implicated therein, he admits it. That contradiction shows that the explanations being given by the accused in 313 when the circumstances are put is not accurate. And that becomes an additional circumstance in the chain.
Last one.
Last, Rumi Bharatto is where the accused has given patently false answers. Here, false answers are evident when one looks at the record matched to the 313.
Very well. That is all. Mr. Mohammed, we will start with you. Just don't make it very long, please. Yes.
My lordship, I am very brief,
Please. Yes.
very brief submissions.
Yes.
Mr. Then the council, Mr. Kabir has taken my lords
Microphone, please. Yes.
and placed the facts and the evidence on record. And he has also answered all the relevant questions put to him by my lordships. And I find that I'm in full support of the submissions on all aspects made by Mr. Kabir, and I go by that. In addition to that, very briefly, in addition to that, if in support of the conviction, whatever has been recorded by in support of this charge, what was framed, if my lordships are convinced that charge is correct, in that event, my lordship, that I may draw the attention of the already brief submissions have been, references have been made by my learned counsel about the admission part of the facts, what happened at the PO by the accused persons during the examination under section 339.
So now you are addressing us on CRA 2.
Share 2.
Yes.
The admission part, what they have admitted during their examination under section 313 CRBC. If we look into the fact, it is admitted by accused persons that this M. Josh was pushed and he fell down. They have admitted, is admitted facts.
It is the CRA 1 to delay.
My lord, page 75.
Yes, yes.
Page 75, my lord.
75.
Question number 10.
75.
Page 75 of the paper book.
Paper book. Yes. Yes.
Question number 10.
Yes.
Question number 10, it was framed, we will see further stated that then Rajesh Paul shouted at you and kept his hand on your shoulder. Then you became angry and asked Rajesh Pal that as to how he kept his hand on your shoulder as you were on duty and why he was shouting after taking liquor. And you asked him to come to police station and call a police van. What do you say to that? Then the answer, it is true. It is true that Rajesh put his hand on my shoulder and told me to, I told him
To remove the same.
to remove the same and asked him to uh,
The place.
asked him to left the place as they were intoxicated. So this has been admitted at the spot. Then, my lord, may come to page 80. Josh, question number 37,
Yes.
page
So
80.
what is the point, Mr. Mohammed?
I'll come to that. I'll come to that, my lord. Page 80, examination of Anjos, question number 37. He admits, Anil pushed me and I fell on the ground.
Yes.
Then, my lord, page 86, examination of Howladar, question number 10.
Yes.
P23 for the stated that then Rajesh Paul shouted at Anjos and kept his hand on his shoulder. Then he became angry and asked Rajesh Paul that as to how he kept his hand on his shoulder as he was on duty and why he was shouting after drinking liquor and asked him to come to police station and call the police van. What do you say to that? It is true. That part has also been admitted. Then again at page 88, question number 21 and 24. It has been admitted.
Yes.
Question 24, period 4, for the stated that he then puts accused Josh and then he fled away from the place towards sea. What do you say? It is true. So these are the admitted position.
No, how does this help you? How does yes, it is true answer help you?
My lord, I am coming.
No, just give us your point, please.
Only
We are understanding the answers.
Only on that. Only on that. After all this incident, these accused persons, they came to the PS Aberdeen and a GD entry has also already been referred to. GD entry was made. There is no reference as to what they admitted. They should have come on the GD. If that was the situation, it should have come on GD. And a public servant, while discharging his duty, have been assaulted and pushed by the accused persons, there should have been an FIR against him. It's a serious violation. They were prevented from discharging their duties while being on duty. They have not divulged. There is no mention in the GD. There is no FIR laws against that Anil deceased. Why? What was there in mind?
Very well. So all that is a pre-conviction procedure, which you are saying there are some lapses.
My lord.
Yes.
So these are, the strong circumstances that goes against the accused persons in making a chain of the circumstances.
Anything else, Mr. Mohammed?
And my lord, about that coconut plantation, the site plan, what has been referred, and the London trial judge has also found that there is, in the site plan, there is no, but if you go through the evidence of PW 27 at page 70, Athena soil. My lord, he, in his cross-examination, In cross-examination, at page 71, it has come on record that there is a coconut plantation in between the beach and the restaurant. In cross, it has come. The boy who fled away crossed the coconut plantation area. Then page 72, the coconut plantation area is about 100 meters away from the restaurant. So there is a coconut plantation. It has come in cross, it has not been denied. So absence of that coconut plantation from the site plan loses its significance. It has been admitted by the defense that there is a plantation.
So even if the plantation had been present in the site plan, then how would it have prevented acquittal?
By law, that has been given a trial court has given a weightage to that absence of plantation in the site plan. There is a plantation. So why that weightage is given only to get away with the punishment?
Yes, anything else, Mr. Mohammed?
For that, my lord, in support of the submissions on the rest of the points, what have been already advanced by learned counsel on behalf of the brother of the deceased. Make
You
it
are allowed.
best.
Very well. That is all. Thank you. Mr. Tabriz, just 5 minutes, please.
Can we come back tomorrow, madam?
Can we?
Both of
You and who?
both of us are in the same prayer. Will not take more than 10 minutes.
Very well. Yes, learned counsel appearing for the petitioner. Petitioners in both, for the appellants, in both CRA 1 and CRA 2 of 2023 have made their submissions. Stop. Next, list this matter tomorrow for hearing learned counsel appearing for the accused, comma, as prayed for. Stop.
Great, my lord.
Item number 12, WP 19 of 23.
Lord, I am appealing for the petitioner.
Personal difficulty today. Mr. Kumar, if you want, you can start your submissions or we can put it tomorrow.
Let it be tomorrow, my lord. It will take some time, my lord.
Yes, so why don't you at least
Uh-huh.
spend that time opening your submissions?
Let it be tomorrow, my lord. I will just go through.
Adjournment is paid for on behalf of counsel appearing for the administration. Capitals, stop. List this matter tomorrow is paid for.
Blind.
You're for the Union of India? UPSC. Next.
Item number 13, WP 18 of 2020.
These two matters are connected to the stamp duty issue, my lord. The main matter is, lead matter is coming tomorrow. They have filed our opposition. Reply will file.
Yes, affidavits are complete.
We have filed our opposition.
We are not using any reply, but it's absolutely point of law. Just
Yes, since learned counsel appearing for the administration submits that the main writ petition is due to appear,
That is an
that the
appeal.
main appeal is due to appear tomorrow. Comma, list this matter tomorrow.
Blair.
The main appeal is MA 17.
MA
MA 7.
2020.
My lord.
Let all the writ petitions and the appeal be appear as connected matters.
Item number 15, CRA 9 of 2022.
I am appealing for the appellant, my lord. The conviction is under section 4 of the postcomment.
Item number 15,
15, my lord.
yes.
It's an appeal. A date may be fixed, my lord.
Next circuit bench,
My lord.
yes, learned counsel opinion for the appellant submits that this matter will take substantial time for being heard. No, submits that the hearing of this matter will take substantial time. Stop. Who is for the, Ms. Zinu? Yes. Next, let the matter be placed before the next circuit bench.
Obliged.
Item number 16, CRA 11 of 2022.
My lord, in this, I am for the appeal. This is again a case.
Time, on what terms?
I'm not ready. In this matter.
Next circuit bench? Yes, the learned counsel appearing for the prosecution. Seeks an adjournment, stop. This is matter before the next circuit bench. Manoj. Next circuit bench. So we will sit after 15 minutes.
Telling one matter. Let it be listed tomorrow.
Mentioning what?
One matter, this is after 23rd April, this was never listed. And I have been engaged in this matter yesterday.
23rd April, we haven't crossed 23rd April.
23rd April 2023, after that this matter.
What is it? Don't say this matter. What kind of matter is it?
This is where this writ matter was challenging the termination of
Then
contract.
why are you mentioning it in the second week of our circuit?
My lord, I have instruction that to withdraw this matter. So that's why I'm mentioning.
Then why are you saying that it's never been taken up from 23rd April?
From the record, I could find that it was never listed.
You want to withdraw it?
No, I want to withdraw it, but let it be come to the list, then I'll mention.
And are you mentioning about notice?
No, already, Mr. Chakravarti is there.
Tomorrow, my lord, after first half, my lords have to travel to Kolkata. But it's okay, Mr. Dwivedi will be there.
Very well, this is matter tomorrow. Calcutta. Yes, any other?
But I pray your lordships kindly to mention criminal revision, Domestic Violence Act. This court was hearing it and had passed an order for me to file an affidavit by the 29th.
Yes, the other thing, sorry to interrupt you. Mr. Chakraborty had mentioned some matter where or was it Mr. Kumar who had said that the arguments were over and was supposed to be for judgment and then no, Justice Mukherjee and Justice
That Ms. Nag had mentioned.
Mrs. Nag. And then you had
And I
said
had
that
said
there were
that
similar
there were
matters. Yes,
similar
please give us a
cases.
list of those matters, all right, with the last date when those matters were heard.
Madam.
Uh,
Those records, my lord, I had ascertained from the court staff as well as this thing. The records have been sent also. There's nothing here.
So
Probably
you don't know which dates,
the
how many
server, the
appeals
server
have been-
has, I know 2 of the appeals which I had done. The server has the last orders. and
Yes,
nothing
so give me the last
Madam.
orders. Give me the last orders and I will ask Mrs. Nag. I just need the particulars, that's
Madam.
all. How many pending and last orders, bench. Yes, yes,
Alright, so the order was for me to file an affidavit disclosing certain things before this court by the 29th. For that, I needed the certified copy from the learned court below that has been made available only on Friday. And in the meantime, the matter was supposed to come in the list. It has not come. If it can appear, my lord, then a direction.
it's a CRR.
CRR, domestic violence.
Yes, but then it will take some time, Mr. Kabir.
It may take some hearing, madam.
Yes, then you should have done it in the first week.
I do not have those certified copies, my lord. I got them only on Friday. We applied for them in advance.
Very well, let it be in the list on today's Monday, on Thursday.
Madam,
Any other mentioning?
be prepared.
My lord, item number 83 and
73, madam.
yes.
This we have mentioned last week also, my lord.
You're appearing in pairs now in most matters. No,
Two writ petitions, the issues are identical, my lord.
yes,
Mr. Kumar's matter was in court number 2, my lord. He has mentioned and released it so that both can be taken up together to avoid difference in the judgment, my lord. This very small issue, my lord, if it can be taken up tomorrow to.
what is it? It's a writ petition.
Writ petition, my lord.
And why in the second week? Why not in the first week? Why did not?
We have mentioned, my lord. My lord said it will be appear on 5th, my lord.
Very well, tomorrow.
My lord, can it be specially fixed? So because day after tomorrow, I will not be.
Specially fixed. But you are the petitioner, you will not give your rejoinder. What about Mr. Chakraborty?
While their affidavits, no, Mr. Kimbala. I'll not be using any reply. It's absolutely point of law, my lord, interpretation of one provision of the Andaman and Nicobar Island Land Revenue Land Reforms Regulation. Just one clause that needs to be interpreted. Now, because of the stand taken by misinterpreting the provisions of law.
And when was the order given for directing affidavits?
Affidavits, which was given long back, my lord. They have filed it, but
Then why are you mentioning now for before this bench?
to upgrade it, my lord.
For hearing, my lord.
It's not
It's ready,
leaking,
madam,
it's quite down in the list, my lord. This lady, my lord, she wants to sell this property for the treatment of her son. Now,
Very well, give it tomorrow.
okay.
Yes. call on the list.
73 and 83.
Item number 1. Here are 26 of 23.
My lord, I am appearing for the petition, my lord. Here already there is an interim order, my lord.
And my lord has extended it up to 28th of February, my lord. So my lord, I pray it's ought to be, my lord, under the heading hearing, my lord, let maybe taken up.
Which issue was this, Miss Zinu? Which one is?
My lord, this is against the conviction under section 279-304A of the Indian Penal Code, which was affirmed by the appellate court also.
So I extended the interim order given by the,
My lord, on 18th of December, interim order was granted. That was extended by my lord
very
till
good,
28th,
yes.
my lord.
Meanwhile, low court records can be called for.
Very well, by an order dated 30th January 2024, the interim order passed by a coordinate bench was extended till 28th February 2024. Stop. Next, learned counsel opinion for the party submits that the matter should now be placed as a hearing matter in the list. Stop. Next. Give me a date, please, or before the next circuit bench.
Next circuit.
Next second.
Let the matter be placed before the next circuit bench under the heading for hearing, as paid for. Stop. Let the lower court records be called for in the meantime.
My lord, I'm grateful, my lord. It's mine.
Yes, yes. I have filed for vacating as we started.
And I'm going to join it. Okay.
Item number 2, WPA 11 of 2024, item number 3 and 4.
This is that.
My lord, before my learned friends start, my lord, an unusual request. So far as item number 2 is concerned, Mr. Binu has challenged the virus on behalf of one of the auto unions. I am representing the other auto unions, my lord. We have taken out, it's being affirmed, an application for addition of parties because this policy affects all auto drivers in the islands.
So what is it? What is the prayer?
I'm asking your lordship to defer hearing for a few days. My application will be
No, no.
confirmed and listed, my lord.
Because I can't pronounce any judgment if I defer it now. Yes, yes, Mr. Chakravarti.
My lord, the earlier bench, my lords, had granted us liberty to renew our prayer for vacating the
My
interim.
lord, the matter is otherwise ready, my lord. I am ready for argument. I will start my argument. There are only
Yes.
two issues, my lord.
Show me the earlier order, please,
My
Mr.
lord.
Chakravarti.
Lord, the order passed by Justice Shampa Sharkar. My lord has passed one order, will be before that.
No, I've seen that, 10 January.
My lord.
Very well.
I filed my reply, my lord. The matter is ready. My lord, two issues are there, my lord. My lord,
Yes.
the issuance of auto rickshaw permit is governed by the Motor Vehicle Act and the
1 minute. So what is before me is a can. What is the can?
Plan is for vacating interim order.
But that was treated as an affidavit in opposition and I have used my
Yes,
reply to that.
I've seen that, 10 January.
My lord, my lord,
So now I'm hearing the writ petition.
my lord.
Yes. Yes.
My lord, two issues.
Yes.
My lord, this issue was pertaining to issuance of auto rickshaw permit, my lord, to ply the auto rickshaw in South Andaman district. My lord, the entire affairs of this
Issuance of renewal or issuance of grant?
issuance of grant of
Grant.
auto rickshaw permit.
Yes.
Now, my lord, this is governed by Motor Vehicle Act and there is a rule framed by the Andaman Nicobar administration, my lord. Now, my lord, two foreign conditions were imposed, my lord, which is, to my respectful understanding, that is arbitrary, my lord. First, my lord, in the auto rickshaw, there is a clause in the auto rickshaw permit, which says that the person in whose name the auto rickshaw is there, he will be only allowed to drive this at auto rickshaw, my lord.
Yes.
Nobody else. And there is one more, in that clause itself, they say and the name of the person who has been driver, whose name is given there. But in the permit, there is no such clause. Assuming for argument's sake, if we say this also, that a driver and the owner, the permit holder shall be allowed to drive the auto rickshaw, no other person. My lord, to my respectful submission, it is arbitrary, my lord. It cannot be. There can't be any clause. And there is no such provision under the Motor Vehicle Act.
What is the prayer in your writ petition?
My lord.
Respond numbers 2 and 3 are who?
The Transport Authority, my lord.
Yes. So there are show cause notices which have been issued to you.
My lord, I have just shown those so cause notice to strengthen my argument that on the said scope, so cause were issued, suspension orders were issued, and cancellation orders were issued. And second, my lord, my second ground of argument is, my lord, that there is a clause which warrant that an incumbent who is applying for auto rickshaw permit must hold a local certificate that he is a permanent resident of this islander card. So, my lord, this again I say to my respectful submission, my lord, this is contrary to Article 14, Article 19(1)(g), my lord.
Right?
Because, my lord, no clause could be there debarring a person because we are the citizen of India. Now, cannot debar a person from having the source of livelihood on the ground that I did not belong to this island.
Did not belong means you have to be a resident or you have to be born in the island.
My lord, a person should hold a local certificate, and the criteria to get the local certificate is that a person should be a permanent resident of this island for a period of 10 years.
So if you're not a permanent resident, then you don't get the.
No, my lord, this is their in executive fiat. They have incorporated these conditions which are arbitrary, my lord. Only on these two score I have challenged, and I will.
And you have been issued show cause notices because you're not a resident.
No, so far as that part is concerned, my lord, that part is concerned, we were never allowed to submit our application for auto rickshaw permit since we don't have the local certificate.
No, your prayer B says about show cause notices.
Yes, my lord. Show cause notice with regard to that permit condition, my lord. My lord, may kindly come to 256 and 257, my lord, of their CAN application, because they contended that a document which I have placed at the second page of the document that is wrongly submitted by me, but there also the same condition was there. Therefore, I am relying upon that document. It's 256, my lord.
No, Mr. Kumar, you have to go sequentially.
My lord, this
You don't make your arguments in a random way.
no, my lord. I am first placing, my lord, with regard to that condition part, my lord.
Yes,
Page 256 is a permit, my lord.
yes,
In respect of contract carrier permit auto rickshaw, my lord.
yes.
Now, my lord, can we come to 257 clause 7, my lord?
Yes.
These are the condition, if that has been faulted, my lord, license will be suspended and cancelled. Clause 7 says, the vehicle is not driven by the person whose name has been furnished by the owner to the STA and enter in the permit in the case of auto rickshaw.
Yes.
Now, my lord, I say, my lord, there is no rule, no bylaws. There is
No, how does the court know? How will the court know that which are the two conditions which you find to be arbitrary?
this is the only condition so far as permit is concerned, my lord.
Yes, but you said the other thing is that local resident was there.
My lord, that I will show from the minutes of the meeting because
Yes.
since those who are not the resident, my lord, they
No, but how do I know from 257?
257 is the permit, my lord.
No, that clause 7 is a later addition.
My lord, that is an addition in the auto rickshaw permit. I say that this addition in auto rickshaw permit is arbitrary, I say, my lord.
Mr. Kumar, make your submissions in a specific
My
way,
lord, my lord,
right?
my lord,
The heading says additional conditions.
my lord,
So you have to tell the court
my lord,
when the first conditions came into force and when these additional conditions were introduced.
my lord.
Give the facts completely.
That was introduced in the year 2007.
No, please make your facts properly, otherwise I will just shift you to the next bench, I'm
Hello.
telling you.
2007, my lord.
Yes, 2007, what happened?
2007, by a meeting, they put this additional conditions.
When were the conditions existing from? Can't understand what I'm saying.
2007 onwards, my lord, 2006 onwards.
Yes, show me those conditions, please. You have to show the comparison.
My lord. My lord, may kindly see page number 21 is the resolution adopted by them. That is the minutes of the meeting at page 21.
23rd April.
23rd April, my lord.
Yes. Yes, so what are the conditions which
Hello.
they added to?
My lord, my lord.
Mr. Kumar, if you're not
Hello.
ready, you have to come back.
My lord, I will come back, my lord.
What did you feel? What did you believe? That you will just show page, whichever page that is, page 256, and the court will hold that it's arbitrary?
My lord, no, not
You
at
have
all.
to place it in
My lord, my lord,
context.
my lord,
That this was what was there from before, this was what was added,
my lord.
and therefore whatever additional conditions may not be contrary to the articles, but then, of the constitution. But then you can't just say 256, this is the condition and it's arbitrary. Court can't,
No, my lord.
at least I don't pass my judgments that way.
My lord.
What else?
So, my lord, I will come back, my lord, because I have to satisfy this court on this court first.
You think this is not an important point?
Absolutely, it is an important
If
point.
it's an arbitrary point,
My lord,
if it's an arbitrariness argument, then you have to show that this was what was the pre-existing rule,
my lord,
this was what was added,
my lord, my lord.
and therefore it's not only one condition. It has, there has to be something in the substratum of the existing rules, which were fine by you. You had no problem with those rules, but you have a problem with the subsequent addition.
My lord, my
Understood?
lord, my lord, my lord.
What else? You argue on the other point.
No, my lord, I will argue not in piecemeal, my lord, because otherwise,
I don't know, you don't have any urgency, Mr. Kumar, to argue the writ
no,
petition.
no, my lord, because since if something has been fallen from my lord, I have to satisfy.
That something has been fallen. It's a normal
My
course
lord, my
which the
lord.
council
My lord.
is to take while placing a matter.
My lord,
You don't know the facts of the matter. Yes, Mr. You are
No.
representing Mr. Sorry, I don't have your name.
I'm appearing in the next two matters.
For the auto rickshaw. What do you have to say?
My lord, I'm coming.
I'm coming means what?
I'm coming to it. I'm just taking out the records. My lord, if my lord permits, second number, third number may be taken up first.
Just tell me your argument, please.
Yes,
How is it arbitrary, unconstitutional?
Yes.
What is it?
yes, my lord. My lord, WPA 846 of 2023 may kindly be taken up.
What is your argument? Don't tell me
Yeah.
that's all you know.
I'm
What's the
just-
argument?
I'm just drawing my attention to page 157. May I read, my?
What is the condition?
That,
which you find-
that representation I have stated, which will more clarify. Then it will be clear, my.
कौन representation of the WPA?
846. Page 157.
So that is not there in WPA 11.
No, here I will just, there was a representation, and after that also they have passed another order. That is the reason I just want to draw my lord's attention to page 157.
Yes,
May I read, my lord?
yes.
This is addressed to the Chief Secretary and Manipur Administration to expunge the clause 7 in the permit issued to the auto rickshaw passenger, which warrant the vehicle is to be driven by the person whose name has been furnished by the owner to the STA and entered in the permit, and to enable us to earn our
No,
livelihood.
let me read.
May I read, madam?
No. Yes, so this clause number 7 was brought out by way of a paper publication.
By virtue of a meeting held by them. The first, there was no reasoning, that was on 2007 first, and there are subsequent meetings also they have affirmed that because of this, law enforcement agencies are troubling the auto rickshaws. And they are suspending, and time to time they are passing order, they are seizing the vehicle.
Yes, yes, so what is your argument?
My argument is this, that is the reason I have this is.
None of you are ready in the matter.
This amounts to.
You know what I do in Calcutta when counsel are not ready in my court?
My humble submission is.
Yes.
So these amounts to, because if I'm running an auto rickshaw, I'm having an auto permit, his name, they say that the driver's name has to be given, then kindly come to page 182. Kindly come to page 182 for 1 minute. To substantiate my argument.
You are Mr. Das.
Yes.
Mr. Das and Mr. Kumar, you do something, please. Tomorrow, because this can't be, the documents are also piecemeal, it appears to be. One thing has some representation, your document has some, I don't know what it is. So you give me a list of dates tomorrow. A composite list of dates on behalf of both the petitioners. There are only 2 petitions.
Third, there is third with respect to the transfer of ownership, that local certificate. Without local certificate, transfer of ownership will not.
So that was an additional condition which came, or that was also introduced on the same day?
That is also because of the minutes it has come up. There is still.
Then why have you not filed one single writ petition challenging both?
Because the first issue came, this transfer of ownership has come first, so we have filed the first writ petition. Then this problem has cropped up, another group has come, different set of petitioners.
Maybe, but you are agreed by the same conditions, or are you not?
No, this the 841 is, they are agreed by the only one condition, due to local certificate, they are unable to get their ownership transferred.
So that is they or you?
I mean, my clients.
Yes, so you are agreed by the local certificate. And Mr. Kumar is agreed by the person who does not own these vehicle driving, that clause number 7. But you showed your presentation of clause 7.
One is with regard to transfer without local certificate, and the other one is self-same as Mr. Binu Kumar's.
Very well, Mr. Das and Mr. Kumar, one composite list of dates tomorrow. All right?
My lord,
Yes.
my lord, I may be permitted to make my submissions on 8th, my lords, because tomorrow, my lords, I'm traveling on the day of.
You make a submission today?
Yes, yes, then I can.
Today?
Yes, yes.
Yes.
My lord may have the vacating application, my lord, which is being treated
Which
as.
is your opposition? Yes.
Yes, my lords, opposition. My lords, the first document, my lords, is the order, my lords, of which my lord has already seen. But my lords, on the 10th of January order, the coordinate.
No, what have I already seen?
My lord, the order of 10th of January 2024 passed by the earlier bench.
Yes.
May I place the order, if your lordship?
No.
Oh, very well. So there are two things on the basis of which, my lords, the interim order has been. There is an interim order only in the first matter.
Yes.
In the other matters, there is no interim order.
Yes.
Only direction for affidavits. So, my lords, the interim order has been passed on 2 grounds. The first ground is the learned single judge has the coordinate bench has recorded that, my lords, the condition was not there in the permit. And the second ground is that, my lords, it doesn't have any policy backing.
1 minute. Yes, yes.
Now, my lords, in my humble submission, my lords,
Yes.
as far as the point of the condition not being there in the permit is concerned, my lords, that happened because of maybe an unintentional or whatever. I'm not attributing anything to my learned senior, but perhaps his clients are not properly instructed, because, my lords, that is a condition in the permit. And in fact, he has also placed it.
What was shown?
Clause 7, which my learned senior.
What was shown to the earlier?
Yes, my
earlier
lord.
bench?
That, yes, my lord, that I'll just point that out immediately. Kindly have page One, if my lords may have para 17, page 11 of my vacating application. What was shown, my lords, to the earlier bench was in the writ petition, my lords, page 198 at 244. If my lord has the writ petition.
198 at 244.
Yes, 19.
And what is paragraph 15?
My lords, they had enclosed the permit of a public carriage as opposed to the permit of an auto rickshaw, because an auto rickshaw is not a public carriage. Permit was enclosed, not enclosing the additional conditions. So, my lords, they represented to the court that this was not, the condition was not there at all. But, my lords, the correct document, my lords, I have annexed with the vacating application. And it is also otherwise there, my lords, with this, kindly have page 256. 256 at 257 of my vacating application.
Yes.
This is the correct, my lords, condition, and my lords will see on the next page, Roman 7, the vehicle is not driven by the person whose name has been furnished by the owner to the STA and entered in the permit in the case of auto rickshaw. So, my lords, clearly, my lords, the condition is there that if this is violated, then the permit shall stand cancelled.
No, so why does it say additional conditions, Mr. Chakraborty? What are the conditions? And what are the additions?
My lords,
The first page doesn't say additional or any kind of conditions.
my lord. My lord, this is the conditions of permit. If you see page 256, my lord.
So it just says 14.14.
Yes,
Conditions
it
of
says
permit
list attached.
Yes,
So, my lord, these are the conditions, my lord,
Yes.
according to this.
yes.
So, this condition was clearly there. However, my was shown to the learned single judge. If my lord has page 198 of my vacating application, that is a writ. And if my lord has 244 of the same, I have annexed all the documents with the application. Page 244, my lord may have for a moment.
Yes.
This is what was shown. This is schedule of conditions.
Completely illegible, Mr. Chakraborty. Can you read it? I can't.
My lord, I can read it. I can attempt to, my lord, read. My lord says schedule of conditions to be attached to the, I apologize, my lord, for that. So, public carrier permits. The permit shall be suspended, cancelled if. Now, my lords, here, my lords will see again, Roman 7 is there. Vehicle is not driven by the person whose name has been furnished by the owner to the ST and entered in the permit. So, my lords, the correct, the condition is there. So, therefore, my lords, one cannot appreciate as to how a submission was made that this condition was not part of
You were
the.
not there on that date. You were, or 10 January?
My lord, I think I didn't have these instructions because, my lords, it was without affidavit.
Yes.
So, my lords, the first part is this condition was definitely there. Where they are, of course, entitled to challenge the legality of this condition. That's a separate aspect. But, my lords, while seeking the interim order, they represented that this condition was not there. So, that is erroneous. Secondly, my lords, on the point, the other point which the learned coordinate bench has recorded is that there is no policy backing to this. My lords, there can be two situations. One is where there is no policy basis at all. And the other situation is there is a policy basis, but the policy is being challenged within the contours of what is permissible to challenge a policy. Now, my lords, on that, my lords, my humble submission, and which I have placed those documents with the vacating application to show that there is a policy decision, and this has been, there are detailed deliberations that have gone into this decision to impose these permissions, and also that it has the backing of statute. So, my lords, if my lords has page 3 onwards, I'll place those documents one by one of the vacating application. The first document, my lords, is a notification of 11th March 2008, which your lordship will find at page 18 of the vacating application.
Yes.
This notification deals with this is a notification under section 68(1) of the Motor Vehicles Act, read with subsection 41, whereby, my lord, the State Transport Authority has been constituted. Now, my lords,
What is the date? 11th March?
This is 11 March 2008.
Yes.
Now, my lords, after this, my lords may have the document at page 20. But this, my lords, may have Rule 50 sub rule 1. This is the Andaman and Nicobar Islands motor vehicle rules, and my lord may have rule 51. Conduct a business of the state transport authority. So state transport authority.
How do I know that this is the Andaman and Nicobar, whatever you're saying, motor vehicle rules?
My lord, that my lord, is a mistake. So first page, the whole thing should have been annexed, my lord. Only the relevant clause has been.
1 minute, Andaman and Nicobar?
This is, my lord, it's mentioned at page 3.
Motor vehicle rules
Yes, my lord.
of which year?
This is my lord's 2006.
No, it was gazetted on 18th April
Yes, ma'am.
2006, but yes.
So my lords will see clause, rule 50 says, conduct a business of state transport authority subject to the provisions of the act and these rules and to the approval of the UT administration. State transport authority shall have the powers to make bylaws, and business of such authority shall be conducted accordingly under the directions of the chairman. Now, after this, my lords may have the first minutes of meeting, which begins of the State Transport Authority dated 23rd April 2007. My lords may have page 21.
Yes.
Now, my lords will see the serial number 2 of the minutes. Eligibility criteria for inter-district tourist permit, auto rickshaw permit in South Andaman. In compliance of Jarawa policy and to control the increasing number of vehicular traffic on the ATR, that is Andaman Trunk Road through Jarawa reserved area, and to streamline auto rickshaw operation in town, following eligibility criteria be followed for the grant of NOC for auto rickshaw and tourist permit. 1. Permit will be issued only to local unemployed people below 40 years of age, and 2. Permitted vehicle should be owned by the applicant. 3. This driving license, of course, is non-contentious. 4. Should submit islander identity card or local certificate. So, my lords, this is the first minutes. Now, after this, my lords, this was examined in a subsequent minutes of meeting dated 21st July 2007, where this condition of 40 years was relaxed to make it 50 years. So, my lords had seen that local unemployed youth below 40 years of age, but this was relaxed to make it 50 years of age. That your lordship will find page 22, it begins, but my lords may have page 49. Page 49 of this document. Kindly see page 49, the second last paragraph on the page. STA has examined the proposal and decided to increase the age for issuing auto rickshaw permit from the existing 40 years to 50 years, and also to have uniform criteria all over the Union Territory for issuing auto rickshaw permits, i.e. local persons below 50 years of age possessing self-PSV driving license with the other condition that he has to drive, and only one auto rickshaw permit to be issued. Now, my lords, there was a representation was in fact made against this policy.
Which part did you read out, Mr. Thakur?
My lord, I read the portion in bold, which is the second last paragraph of page 49, which my lord talks about both things, local person and 50 years of age, and that person has to drive the vehicle. Now, my lords will see this, there was a representation made against this policy.
Yes.
That representation, my lords, was decided on 9 June 2023. Those minutes begin at page 116.
This is the one which Mr. Das was pointing out. No, that that we made a representation, but it was still.
My lords, it was made by a group of people.
Our representation.
It may not be theirs, but it was, in a sense, it's a class action. My lord, will see page 116, and my lords may have page 150. 116, the minutes begin, and my lords may have page 150.
So representation made by who?
My lords, the representation, my lords, was, it did not have any address or contact number of the persons who had signed it, but my lords, a group of people had made the representation. Now, my lords may first have page 150, where this issue has been decided.
Yes.
The members after the chart, the members of STA were appraised was appraised about the past decision of the authority regarding grant of NOC for auto rickshaw permit with a STA minutes dated 23rd April 2007. That NOC will be granted only if the applicant fulfills the following conditions. One, permit will be issued only to local unemployed people below 40 years of age. Two, vehicles should be owned by the applicant. Then four, submit islander identity card or local certificate. Then, my lord, there is a reference to the last minutes where this was relaxed to 40 years was relaxed to 50 years. Now, after this is a discussion. Now, my lords may have page 168 where the representation is discussed. Kindly see, my lords, paragraph 3. Representations under signature of several individuals had been received on 24th May 2023 regarding non-acceptance of transfer of ownership of auto rickshaw by Transport Department due to non-submission of islander card or local certificate for obtaining NOC for PCC auto rickshaw / transfer of ownership. It is mentioned in the letter that the applicants hail from West Bengal and are residing in these islands since many years. Being unemployed, they are driving auto rickshaw for their livelihood. They are in possession of the following documents as detailed under: 1, Aadhaar card; 2, PAN card; 3, driving license. STA, after deliberation, decided that since the applicants could not submit islander card / local certificate for obtaining NOC to purchase auto rickshaw, their request cannot be considered, as furnishing of local certificate islander card is one of the mandatory conditions for obtaining auto rickshaw permit. Reply to the applicants may be given in light of guidelines framed by STA with its meeting dated such and such, which has been examined and accepted in subsequent meetings. Now, my lords, there were several writ petitions.
So, Mr. Chakraborty, this bold paragraph which you just now read,
My lord,
that says that local certificate, islander card, whatever. So this was discussed and given effect to by this meeting, by these minutes.
no, my lords, it was
No,
First
STA
time in
after
2000
deliberation decided.
no, my lords, first time in 2007, then subsequently reinforced in 2017. Then a representation is received, and in 2023 they say that we are reinforcing this, and therefore we are not accepting this representation.
So that local certificate, islander card was there since 2007.
2007.
Very, yes.
Now, my lords may see that there are actually, my lords, a large number of writ petitions were filed. The interim order was passed in this particular writ petition where the vacating is filed. The orders passed in the earlier writ petitions, which are also, my lords, listed before lordship, is from page 251 to 254 of this vacating application, which is only to show that, my lords, interim order was not granted. There were only directions for affidavits. 251 to 254.
Yes.
Now, my lords, so far as the reason as to why, my lords, this kind of policy has this now, therefore, all these documents have been shown only to establish that there is a policy, for good or bad, my lords. There is a policy in place. It is not as if there is no policy. And the policy is being issued in pursuance of the powers of the State Transport Authority under the Motor Vehicles Act.
And policy which would be evident from the minutes. That's what you're saying.
From the minutes. Now, my lords, what is the justification for this, my lords? In my affidavit, my lords, we have tried to justify, my lords, there is an extreme pressure on natural resources so far as Andaman and Nicobar Islands are concerned. Around 92% of the land is under forest, 3% is under agriculture, and rest of it is revenue land. Now, my lords, because of the unique characteristics of this place, my lords, there is a great, and the only employer here is the government. There are hardly any private employers, and the resources are limited, and therefore, my lords, steps have to be taken which are commensurate with these conditions. My lords, the idea here is, my lords, to meet the requirements of the local unemployed youth. Because, my lords, we do not want a situation where, my lords,
yes,
there are rackets or there are large number of syndicates which are operating these auto rickshaws, which will eventually result in driving the local youth out of employment. Because, my lords, the policy is...
Now, what do you mean by syndicates?
My lords, because the allegation or the apprehension of the administration is
Yes.
that these people who are coming from the outside, a large, and there are two aspects my lords will appreciate. One is that under the present policy, the person who is applying for the permit has to drive. So my lords, this is in aid of what? This is in aid of the fact that only one permit per person.
Yes.
And not a situation where one person purchases 20, 30, 40 auto rickshaws and he engages people from outside or from wherever who are employed under him and who will be plying the auto rickshaws. So my lords, there are two things, my lords. First is that the administration is apprehensive that, my lords, if a large number of people are, if this condition is taken away, that is the person who owns the auto rickshaw doesn't drive the auto rickshaw, then there is a possibility that, which is happening, my lords, that, my lords, individuals will own a large number of auto rickshaws and then they will have persons from outside will ply these auto rickshaws.
Yes.
Now the interest, and this will eventually result in resulting in unemployment of the local youth. Now the second part is that, my lords, that requirement of domicile, my lords, there can always be a requirement of domicile, my lords, unless it is arbitrary in some manner, my lords. The fact that a local islander card only shows that you are living in the islands for 10 years. So, my lords, the purpose really is again to provide employment to local unemployed youth. So, my lords, we cannot afford rampant commercialization or a situation where, my lords, there are a large number of people coming from outside and they are kind of, because, my lords, there is an ecological aspect also, my lords. The ecological aspect is, my lords, because of the nature of the geography, my lords, and the topography of this area, my lords. The idea is, my lords, to have in a sense restrict consumption, because, my lords, the more, if we increase the population, my lords, then tomorrow, my lords, the more population means more waste.
Population of auto rickshaws.
No, my lords, individuals, people. My lords, maybe it is a bit far-fetched, but, my lords, only 3% is under agriculture. My lords knows, my lords, in several circuits, some of the earlier honorable judges have also commented in different matters, my lords, that, my lords, a jackfruit, my lords, here, which is a jackfruit is a local produce. It is homogeneous, my lords. It is produced here, my lords. That is 750 rupees a kg. Something which is locally produced is so expensive, my lords, and everything else comes from the mainland. My lords, the price of cauliflowers is, my lords, last someone told me it is around 150 rupees or so. So, my lords, as opposed 160 rupees. 160 rupees is the price per kg of cauliflower, which is sold at 20 rupees in Calcutta and Delhi. So, my lords, these are the conditions.
Don't tell me you're going to Calcutta for that.
No. So, my lords, the idea, my lords, is a peculiarity. I appreciate, because, my lords, I am also coming from the outside. So, I try to keep my consumption and create as less waste as possible. But, my lords, the same thing, my lords, there is a huge influx of people, my lords, coming in from West Bengal or other parts of the mainland, my lords. That will result in an imbalance, my lords, because, my lords, there is no private employment, my lords, or the government also has limited resources. The natural resources are also limited. So, my lords, in fact, I am told Mr. Kabir is appearing for another union of local autowalas who are in fact supporting this policy. Because, my lords, eventually, my lord, there is a larger social good that this policy intends to meet. So, my lords, our humble submission is.
But Mr. Chakraborty, while I understand where you're coming from, that is not the domicile part, but at least your arguments part. It is also true that there may be many people here in the islands who are living here but don't have an islander card, or who are living here, say, for 9 years. All right. So, would you be depriving them of employment?
My lords, there is a policy of having an island.
I'm not talking about the floating population.
My lord.
The people who just come to the islands to see if there's any job and then they hang around for a while and they go back. Not that population.
My lord.
But there may be others who have been here for a long time.
My lord.
But they don't have an islander card or whatever that card is called. All right. What about their employment?
My lords, they will get the islander card after 10 years, my lords. There's a government process, my lord, that they'll get the card. Why, if they have spent 10 years, they'll get the card, my lords. Why, in my humble submission, my lord, the other aspect, my lords, which I'm trying to emphasize is, these people, they were running the operation. There are two parts, my lord, just to explain that query which had fallen from your lordship. A certain number of people are aggrieved by the fact that there is a requirement that you need an islander card to get a license. That is one set of people. The other set of people are saying that there is a condition in the license which we are challenging. We are not happy with this condition that the owner has to drive the vehicle. So, my lords, so far as the second set of people are concerned who are unhappy with this condition, contrary to my lords, the rationale on which the earlier bench had granted the interim order, the condition doesn't exist. But given the fact that it is admitted now that the condition does in fact exist, it's an additional condition, but it exists. Then there is a subsidiary argument, my lords, that having received the license on the basis of that condition, is it open to them, my lords, to then challenge that condition so far as the issue of owner operating the license?
No, but I thought Mr. Kumar had said that there was some additional subsequent condition which was
Yes, no, it is called additional condition, but admittedly, Mr. Kumar will also not dispute the fact that that this condition was accepted, which is why they're applying the auto rickshaws.
yes.
Now they received the permit on the basis of accepting that
And
condition.
that condition has been around since 2007.
Yes, my lord.
Yes.
Now my lords will see the suspension order, which is the immediate cause of action on the
So
basis.
why would they challenge it after 24 years?
Because it has been, because their license has been suspended for violation of that condition. So my lords will see.
So what is the board minutes is that subsequent event?
The minutes are from 2007.
Yes.
Now this policy has been in place. Now the licenses have been issued based on this policy.
Yes.
Now, because in recent times there has been an influx of people who are actually drivers from the mainland who have come and who are operating these auto rickshaws while they do not own the autos, my lord. So therefore this was discovered. When this was discovered, show cause notice was issued, and then my lords will see page 255, the suspension order. There is a suspension order because of which they have now approached the court.
Very well.
Kindly have page 255 of this vacating application, where my lords, this is a common, in fact, the orders are similar in all the matters. May I just read this, because this is what is really the challenge in the writ petition. Whereas Shri, this is one of the suspension orders. This is 13 December 2023, whereas Shri M. Kavyarasan, son of Murugesan, resident of Sainath Store, Barut Godown, etc., is the owner of passenger auto rickshaw bearing registration number such and such, having route permit such and such, to ply in all routes of South Andaman. Whereas STA, in its meeting dated 23rd April 2007, framed certain guidelines, additional conditions for obtaining NOC permit for plying passenger auto rickshaw. And whereas NOC for passenger auto rickshaw permits are considered by STA and issued based on an undertaking with the declaration that she is not having any auto rickshaw in her name, along with other supporting documents furnished by the applicant in order to comply with the guidelines framed by STA for issuance of NOC for passenger auto rickshaw. Whereas Shri such and such had applied for NOC for plying auto rickshaw on all routes of South Andaman, vide his application dated 12 December 2006, along with required documents establishing his eligibility, including an undertaking stating that he does not have any passenger auto rickshaw in his name. Whereas on the basis of documents and declarations submitted by such and such, STA issued NOC for purchase registration of passenger auto rickshaw to obtain permit to ply in all routes of South Andaman. Whereas against the said NOC, Shri such and such purchased a passenger auto rickshaw and got the auto rickshaw registered in RTO. Thereafter, he applied for permit in the STA section with his application dated such and such and obtained route permit. And whereas one of the general conditions at serial number 7 is that in case of auto rickshaw permit shall be suspended, cancelled, the vehicle is not driven by the person whose name has been furnished by the owner to the STA and entered in the permit. And whereas a report has been received from Deputy Superintendent of Police Traffic that the above passenger auto rickshaw bearing registration number such and such was found driven on 5th July 2023 by an unauthorized person whose name has not been furnished and entered in the permit, thus violating serial number 7 of the permit conditions and provisions of MV Act. Whereas plying a passenger auto rickshaw other than a person whose name is not entered in the permit is violation of prescribed permit conditions and found to be serious violation of section 86(1)(a) and viewed seriously by STA. And whereas to give an opportunity to the permit holder, a show cause notice MT such and such dated such and such was issued to Shri M. Kavyarasan as to why his auto rickshaw permit should not be suspended, cancelled for violation of permit condition, and whereas he did not respond to the show cause notice, by which it appears that he has nothing to represent on the violation. Now STA has careful examination of the case, orders the following, and then this permit is cancelled. And then my lords will see an opportunity is given to him, he may make a representation before STA if he so desires on the suspension made above. Permit holder is also directed to furnish the details of driver for driving auto rickshaw within period of 7 days from the date of issuance of this order, failing which permit will be cancelled. So, my lords, he did not answer the show cause notice. An order is passed, which again gives him an opportunity to make a representation, but he chooses to come to court. Now, my lords, the other submission is the argument that is being raised is that this is derogates the provisions of the Motor Vehicles Act.
Yes.
However, my lords, under the Motor Vehicles Act, under section 86(1), my lords, the State Transport Authority has the power to make rules in the larger public interest. So, my lords, it is not as if, my lords, the State Transport Authority does not. You have the motor vehicle. My lords, I'll just place that provision. It is there in the Motor Vehicles Act. Section 86(1). Kindly see, my lords, section 86 first of the Motor Vehicles Act.
Oh, 26. Yes, section 86.
86 is cancellation and suspension of permit.
Yes,
The Transport Authority shall, the Transport Authority which granted a permit may cancel the permit or may suspend it for such period if it thinks fit A on the breach of any condition specified in section 84 or of any condition contained in the permit. So, one of the grounds on which, my lords, a permit may be cancelled is a condition contained in the permit. And so far as section 84 is concerned, this contains the general conditions. Now, my lords may also have section my lords, I'll just place the other section, my lord. So, my lords, the section 86 permits the State Transport Authority to cancel a permit. Now, kindly have, sorry, I apologize, section 68, my lords. Section 68 may be seen for a moment. And before that, 67.
yes,
67 says, a state government having regard to A, the advantages offered to the public, trade and industry by development of motor transport, desirability of coordinating road and rail transport, desirability of preventing deterioration of the road system, and desirability of preventing uneconomic competition among holders of the permit, may from time to time, by notification in the official gazette, issue directions both to State Transport Authority and Road Transport Authority regarding etc. Now, my lords may see section 68. Transport Authority. The State Transport Authority shall, by notification in the official gazette, constitute for the State Transport Authority to exercise and discharge the powers and functions specified in subsection 3, and shall in like manner constitute Regional Transport Authority to discharge. Now, kindly see subsection 3 after that. The State Transport Authority and every Regional Transport Authority shall give effect to any directions contained in section 67, and State Transport Authority shall, subject to such directions and say as otherwise provided by or under this Act, exercise and discharge throughout the state the following powers and functions. A, to coordinate and regulate the activities and policies of Regional Transport Authority. B, to perform duties of Regional Transport Authority where there is no such authority. C, to settle all disputes and decide all matters on which differences of opinion arise. C, A, government to formulate routes for plying stage carriages. D.
now how does this help you, Mr. Chakraborty, this part, what you're reading?
My lords, this shows, my lords, that the State Transport Authority, D also says to discharge such other functions as may be prescribed.
Yes,
Now, my lords, the powers of the State Transport Authority are wide, my lords. And my lords, they have the power, my lords, to include permit conditions, even excluding those which are mentioned in section 84. Section 84 contains the general conditions for permits. But section 86 indicates that other conditions may also be imposed. And what are these other conditions, my lords? That has to be read in light of section 67 and section 68. My lords, it is open to the State Transport Authority to impose conditions which would be in the larger interest of the road transport system, and also, my lords, to avoid undesirable uneconomic competition amongst holders of the permit. So, my lords, the powers of the State Transport Authority are very wide. So, my lords, and the State Transport Authority has been constituted in the present case under a notification of the administration. So, my lords, it is open to the State Transport Authority to lay down conditions under a policy. And my lords, a policy can be challenged only it is completely arbitrary, my lords. Because, my lords, whether the policy is so arbitrary, my lords, that it...
But Mr. Chakraborty, are you saying that the board minutes constitute the policy?
My lords, the policy is reflected in the board minutes, my lords. It's a State Transport Authority minutes.
Yes.
So, my lords, my humble submission is, my lord, that this is not a mere challenge to an executive act. This is a
what according to you would be a policy?
My lord, this is the policy of those conditions which were laid down in 2007.
What according to you would be the meaning of the word policy?
Policy, my lords, is the reason, my lords, or rather the recorded reason which pursuant to which an executive act takes place. So, my lords, although an executive administrative act like issuing a suspension order, my lords, that is certainly open to judicial review. But, my lords, when it comes to a policy, my lords, the standards of which the courts have laid down, my lords, that where a policy decision can be challenged, my lords, the threshold is much higher, my lords, for the petitioners to meet. Because, my lords, a policy is the domain of the executive, my lords, in terms of the judgments laid down by lordships and even by the Supreme Court, my lords. So, my lords, where a policy decision, if the policy is arbitrary, completely illegal, that's a separate issue, my lords. But, my lords, can it be said, my lords, that in the peculiar circumstances of that prevail in the islands, that is this requirement of having an islander's card and the requirement of the owner driving the auto rickshaw, is it so arbitrary, my lords, that it should be struck down? Because, my lords, after all, even the right, if they are invoking Article 19, if it is a question of right to freedom of trade and profession, even that is subject to reasonable restrictions. So, my lords, it is not as, and secondly, my lords, whether, my lords, these rights are being enforced by people who are living in the islands, or whether they are outsiders, be that as it may, they are citizens of India, they have a right to practice a profession wherever they wish to. But, my lords, it doesn't prevent the state from imposing certain restrictions or qualifying certain requirements based on domicile or any other principles which are otherwise valid in the eyes of law. So, my lords, in my humble submission, my lords, the peculiar circumstances that prevail here, my lords, they justify the action taken by the State Transport Authority. And in any view of the matter, my lords, the immediate cause of action of theirs is the suspension. Now, the suspension was pursuant to a show cause notice which they did not challenge. The suspension order granted them an opportunity to make a further representation which they haven't availed of. They have chosen to come to the court, my lords, straight away. And secondly, my lords, principle of estoppel will apply so far as the clause 7 is concerned, because, my lords, that is a condition which is part of the permit. So, my lords, they accepted the condition, and then after so many years, they cannot violate the condition and say that it is illegal, because, my lords, they are stopped from doing so. And in fact, both the conditions estoppel applies, because, my lords, they were issued the permit on the basis of the fact that they have local islander card, and they were also issued the permit with the condition that if the owner doesn't drive, then the permit is liable to be struck down. For example, in this, there are cases where in 2006 they have received the permit. Well, these people have accepted the permit, they have been applying the auto rickshaws on this basis for a decade. And now suddenly, my lords, when their act gets discovered and the authority takes an action based on the condition in the permit, is it open for them to now challenge?
Mr. Chakraborty, the whole thing can be looked at in another way. That is, you have given permits to these auto rickshaw drivers on the basis of certain conditions. Obviously, on the applicants fulfilling those conditions. After a passage of whatever, 23 years, 24 years, you suddenly realize that no, the population in the Andamans is increasing. And there are many who are driving autos, but without owning those autos. Therefore, we need to review our policy. And you say that you start issuing show cause notices to persons who are not the owners of the autos, whatever that condition is. Would that not be an arbitrary action on the basis of these persons having rights vested on them since 2007? But the authorities concerned come to a different view of the matter because of whatever conditions now in the intervening, in the interregnum. And then the authorities decide to proceed against those very same persons who were issued those permits. What about that part?
My lord, the show cause notice and the order is issued not to the drivers, it is being issued to the owners itself. It is issued to the person who received the permit accepting these conditions. And the allegation is that you have violated the condition, and therefore your permit is liable to be suspended or cancelled. So, my lords, it is not being issued to the drivers. It is because the permit is issued to the owner. Now,
Yes.
that owner has violated the condition, and therefore the permit is liable to be suspended or cancelled. Now, my lords, assuming that, let me assume even further against the administration to say that, for example, if it is a situation that 2006 the permit is issued, from 2008 or 9, outside non-owners are driving the auto rickshaws and people who are not holding islanders card. And this is an illegal, this is contrary to the policy, contrary to the license, the terms of the license. But in 2017, they suddenly wake up and say that no, this is wrong, and therefore, as my lord, has it fallen to my lordship that because of certain sudden realization that it is changing the, it is having an impact on the islands or the ecology, etc. They suddenly decide that no, we should take action. Now the question will arise that if an act is illegal, my lords, can there be an estoppel against the state on that basis? If a license condition is violated and this violation is tolerated, my lords, does any right get created in the owner of the vehicle or the owner of the auto rickshaw to act contrary to the terms and conditions on which the permit was given? It is not as if it's not a case of suing somebody for damages, my lords, and then that a defense is being raised that no, there is an estoppel against you. Today, my lords, if a permit is issued subject to certain conditions, my lords, and those conditions are violated, a show cause, perhaps in the response to the show cause notice, the person holding the license could have given his explanation that I've been doing this for so many years and nobody has ever raised an objection. How can I suddenly, you cannot cancel my license. You can grant me some time. I will rectify this. I will drive the auto myself or whatever, sell off the rest of the autos. He could have given some explanation or given some extenuating circumstances. But this gentleman chooses not to respond to the show cause notice, chooses not to make a representation. He comes straight to court, challenging the what is otherwise, my lord, may see the order or suspension order has been passed after issuance of a show cause notice with proper opportunity. It contains reasons. So, my lords, it is not as if there is something. If the policy is not challenged, my lords, then this suspension order, in my humble submission, would pass muster that would be my humble submission. Because, my lords, adheres the challenge to the policy, my lords, there is nothing wrong in my humble submission with this cancellation order because it has been issued after issuance of a show cause notice, which contains reasons, and on the face of it, a condition in the policy has been violated. Now, the only way in which they can challenge or get a quashing of this is if the policy is struck down. So then, my lords, my submission would be that they have lived with this policy for 10 years. And, my lords, there is nothing so arbitrary in the policy, my lords, that it should be struck down. So, my lords, that is the...
Mr. Chakraborty, you please do this.
My lord.
Even though I followed your point, but you just give me like a 2-pager tomorrow, please, so that you have the relevant page numbers. And your argument, basically what the page numbers are and what your point is, etc. What is the policy? What was there in 2007? What did they do to violate it in 2023, whatever? Then show cause. You know what I mean.
My lord, Mr. Dwivedi may be permitted to hand it over because my lord, I
Yes,
won't be
yes.
there.
No, you are there in the first half.
My lord, I'm
Oh,
there in
yes,
the
yes,
first
not in the
after
second.
division,
Yes,
and
that's-
day after I'm not there, my lord, the 8th I'll be.
Yes, yes. But please do that before you leave.
Yes,
towards-
yes, my lord, I
yes.
will do.
And Mr. Kumar and Mr. Das, tomorrow, now that you've had the benefit of hearing Mr. Chakraborty, you'll be better positioned that
Yes.
way. Yes, and you please also get your one composite as to what your matter is.
My lord.
What is the difference between the two matters?
My-
All right. You are not aggrieved by the local resident card.
No, my lord, I have challenged both the aspect. They have
Hmm.
challenged both the aspect and two separate writ petition. That is the only difference.
And Mr. Kabir, if your application comes up, so you're supporting the administration.
We are
Yes.
the other auto unions. There are a total of 9. The
Yes,
others who have been part of this policy over the years. We
yes.
have always had one auto per person, one permit per person. We have applied and we have got it and we have always abided by the rules. Now there is a commercialization of something which was meant to.
Well,
be
Mr. Kabir, I will hear you only when your application is
My
there.
application, if would your lordship's right, if I can get it, then it can be listed tomorrow with these.
Yes, I will say that.
100.
You haven't been given a number as yet. Yes, learned counsel opinion for the petitioners. In how many petitions do I have in my court?
My lord, I have only one writ petition.
No,
My
there-
elder friend has 2 writ petition and
Yes. What?
No, no, your item number won't have.
Similar matter.
It's in the, what is the
But
item?
that's not running in the list.
It was mentioned on the, all together mentioned, but that is not in the fact.
Very well.
I think my lords may see the serial number, I think this is serial number 97 is filed by Ms. Nag.
97.
97 is there,
two
but
matters are there, I have been told.
there is, I think, one more matter.
Then you also include item number 97 and Mr. Chakraborty, the other one. We'll give you the other number.
और एक कौन सा matter?
Yes, learned counsel opinion for the petitioners in the 5 writ petitions before the court. So the total of 5
Yes, my lord.
in the 5 writ petitions before the court are aggrieved by 2 conditions imposed by the administration / STA with regard to plying, PLYING, plying auto rickshaws in the islands. Stop. Next, learned counsel opinion for the STA has made his submissions as to the impugn show cause notices being backed by a policy decision taken by the STA in its board meeting held on, what is the date?
No, no. The first, my lord, the first one is 23rd April 2007.
23rd April 2007. Stop. Next, Mr. Kabir, comma, who is present in court, submits that he has filed another writ petition on behalf of,
No, ma- intervention.
he has filed an application for intervention in which one? Which writ petition?
Mr. Binu's one, the first one, 11 of 24.
In WPA 11 of 2024, which is also required to be heard. Stop. Next, list all these matters tomorrow. Stop. The application for intervention shall also be in the list if the application can be made ready
I'm great.
by tomorrow.
That's
Sure.
the other is WPA 844 of 2023.
So
The last one.
97 plus 840.
844 of 2020.
And please get your the short notes tomorrow.
My lord.
Great.
And Mr. Kumar, tomorrow, make your submissions.
Item number 5, CRR 14 of 2024.
I am for the petition in this matter, my lord, sealing the concurrent finding of the
Microphone.
trial court. Sealing the concurrent finding of the trial court as well as the first appellate court. I filed this revision petition before my lord.
Yes.
I was convicted under the Wildlife Protection Act for 3 years.
He is already on bail.
I have
He-
paid for bail, my lord, as well as suspension of the sentence passed by the appellate court and the trial court.
This is an application for
Revision,
revision.
criminal revision.
And what about the application for bail?
It is there, my lord. 2 crime petition is there, separate. One for stay of application, another is for suspension of sentence.
He
Till
may
the
continue
disposal.
on existing bail and low court records can be called for.
When was the bail granted to you?
During the appeal period, my lord.
Show me that order, please.
My lord, may kindly come to page number 53. 55, my lord, I beg pardon. The convict appellant is directed to surrender before the court below within period of 1
This
month.
is not the order.
Yes, which is the order, Miss
This is the judgment when
Ago I was given with this brief, so I was just reading right now, so I got it to know that it's a.
my lord, the appeal was admitted, my lord, I was granted bail.
So show me that order.
That order is not annexed, my lord, because it is a matter of Maya Bandar. So what I received.
So then what is the crime for then? There are 2 crimes. What are the crimes?
This for suspension of sentence in, along with that, I have enclosed the judgment copy,
Yes, it says on existing bail.
my lord.
So that's crime 1. So you will not annex that
Also have
order.
been annexed with the.
That's your prayer. Release the convict on existing bail. So where is the prayer? Where is the order of bail? Be stayed. The judgment be stayed.
My lord,
Interim judgment be stayed.
my lord, till disposal of the revision.
Yes, what do you have to say, Ms. Zinu?
Lordship, I would request this honorable court to bring the case record because it's a Maya Bandar case. I haven't gone through anything and few minutes back only I was given with it. So let the low court records be called first.
But in the event if this order is not suspended, my lord, then I may be arrested by the police at any
No,
point
can't
of
be.
time because.
He has already, as per his
My
submission,
lord,
he is already enlarged on bail.
my lord, when the appeal was admitted, now the appeal got disposed of, so I have come up before this.
How will I give you an order? You haven't even annexed the order of bail. How will I pass that order? Not on your
My lord,
submission.
kindly see the judgment I have enclosed, my lord. In the last part, it is mentioned that I should surrender before the court below. If I am in the judicial custody, there is no question of surrendering myself.
Very well,
before
get
the
the
court.
order of bail tomorrow.
Can it be day after tomorrow, my lord, so that.
Very well. I will not pass any orders in the absence of the existing bail. I cannot.
Lord, at least one crime may be kindly allowed that the judgment be suspended till.
How that can be?
Till the revision, till the revision.
Absolutely not. No, that cannot be done in law. Yes, although CRAN 1 of 2024,
Or else may I request, my lord, that the LCR may be called for and it may be kept on
That is what
Friday.
I was making submission.
May be kept on Friday in that event.
no, Friday what? That's the second last day of.
Or Thursday, my lord.
No, it's not
it's-
possible to go.
it's for admission, my lord. My lord, why my sister is taking that pen, I fail to understand.
No, I
It
was
is-
trying to understand, Mr. Gobind, why have you not brought the papers?
My lord,
And
this
that's
is,
not
my lord, this is from Maya Bandar, what I have got, I have enclosed and I filed it, my lord, because there is a limitation for time.
Well,
Kindly see.
get the order of bail, I will put it on Thursday. Yes,
In the meantime, LCR may kindly be called for, my lord, if it can come.
very well. Although the applicant has paid for release on an existing bill, comma, the application slash tran 1 of 2024 does not enclose any order or any such order. Stop. The other application, next, is for stay of the judgment passed by the learned additional session judge, comma, Mayabandar, dated 29th December 2023. Stop. Next. Both learned counsel appearing for the parties. Delete that. Learned counsel appearing for both the parties. Praise for an order for calling for the records so that the applications can be disposed of. Stop. Next, the case, same paragraph, the case is of the Mayabandar of the Learned Sessions Court at Mayabandar, is that correct?
ADJ,
The Learned Additional Sessions Court at Mayabandar. Stop. Next, list this matter on 8th February 2024. Stop. The lower court records should be called for and be made available to the court on the returnable date.
Declare void, my lord.
এটা কোথায় চলে গেল? লিস্ট
Six, up to be at 26 of 124.
So the writ petition was supposed to take steps at two parties.
I can't understand, Mike.
Some of them have been directed to serve for adding them. So there's a bereavement in the family of the writ petitioner, so steps could not be taken. This matter will be taken up in the next step.
This is the matter which was, which I had placed before the next circuit and then.
No, this is not the one. It's not. the
Yes, learned counsel appearing for the petitioner praised that the matter be placed before the next circuit bench on the ground that most of the respondents could not be served due to a bereavement in the family of the writ petitioner. Stop. Next, list this matter before the next circuit
Obliged.
Obliged, my lord.
as prayed for.
Item number 7, WPA 47 of 2024.
I am asking for the petition. My lord, I have already filed my reply on Friday. I have sought the. I have already filed my reply on Friday. I have sought the copy.
Yes.
My lord, the fact of this matter is that I am the recorded tenant of two landed property. It has been allotted to me. Survey number 94 and 93, both the lands are adjacent to each other. Survey number 94 is a hilly land and 93 is a low land, agricultural land. So first of all, the anticipation that I have to construct my house on my land bearing survey number 93, it has to be developed. So I made an application before the authority, competent authority, for earth cutting permission. That permission has been granted for earth cutting.
Yes.
Earth cutting permission, that permission has been granted. So I have cut down the earth from my hilly land, survey number 94, and dumped the earth in my low land, survey number 93. And 93 has been developed. Thereafter, I made an application to the subdivisional officer with the request to divert an area of land 600, because survey number 93 area is 4,800 square meter.
Yes.
I seek permission to divert an area of 600 square meter only for construction of my house. Their application was pending for years.
Divert means?
Diversion, it is agricultural land diverted to house site.
Yes.
So there is a provision under rule 4A of the rule 1968.
Yes.
So there is a format application also. In that format I have applied. And that application get pending. I have requested them. They told me that no diversion is going on. So it has kept pending. Thereafter, in the meantime, I have purchased the house materials also. I have started construction. They issued a stay order, my construction will stop. In this writ petition, I am praying before the, let there be a direction to the authority concerned, consider my application for diversion. They have not considered, they have filed the reply. My lord, kindly come to
Where is your representation?
representation is at page number 21 of my writ petition. Submitted to the subdivisional officer. Rule
Yes.
4A.
Yes.
Yes. This
Back on 20th January 2022.
yes.
Yes.
Now, this honorable court directed
So
the respondent.
what is the undertaking which you gave?
Undertaking nothing.
Page paragraph 6.
Let me come. Under this rule, I have applied.
Yes.
Paragraph
And what happened? They have not decided this.
No, they have not decided. Now,
Yes.
this honorable court directed the respondents to submit a report in the form of affidavit. Now, I have gone through the affidavit filed by them. This affidavit has been filed by an incompetent person. This person, Assistant Commissioner Sultan Naman, he is not a party to this writ petition.
No, what is the
This-
stay order at page 2022?
Yes. Once I have started the construction, they issued this stay order, I have stopped the construction. That is at page number 22. Now, because of the,
So they did not reply to they did not dispose of the representation.
No.
And then they issued the stay order.
yes,
But there is no correspondence between these two, between January 2022 and December
nothing,
2023.
nothing,
Nothing.
neither rejected nor allowed, nothing. My lord, kindly come to their affidavit, what they have stated. They have stated,
Affidavit.
yes,
Affidavit.
their affidavit.
This is affidavit reply, affidavit opposition. Yes,
Report in the
yes.
report says that is submitted that the petitioner Srimati Lakhi Kumari Mandal has applied for diversion of land and the same is registered by this office by RC number such and such in respect of land bearing sub-number 93, measuring area of 600 square meter, situated at Wonderville under Faraganj at the same to Tahsildar Faraganj for report. Now B, that further it is to submit that all the diversion cases, including the petitioner diversion case, is kept in pending for finalization of policy. What policy they are taking, I don't know. Because as per the rule, the subdivisional officer is competent, to accept. My lord, I am reading the rules.
No, but Mr. Sivabalan,
My lord,
if you have not replied to the representation, then how can you issue that stay order?
my lord, that is regarding violation of the rules of section 48. They have illegally diverted, and in that the Tahsildar is competent to issue, has to take steps, otherwise it will become.
One hand, they are not considering my application. Other hand, they are issuing.
My lord, in this connection, I would like to submit that there are 6 mandamus appeal pending before this honorable court regarding conversion of the land. Earlier committee was formed, that committee was caused by the honorable single judge, and the administration has prepared an appeal. There are total 6 number of appeal pending before this honorable court. And as such, we are unable to take any steps till the disposal of that appeal regarding conversion of land.
Appeal is pending since when?
My lord, on 31st January, this honorable court has passed to prepare common paper book instead of 5 paper book. It is that matter.
I don't think there is any stay order.
Yes. Yes, yes. This is
So
the-
that is there.
No, what is the subject matter of that appeal?
that conversion regarding conversion committee was formed
Yes,
by way of administration. That
Yes.
committee has been quashed by the honorable single judge. Thereafter, the administration
committee has been
quashed,
quashed.
by the honorable single judge. Thereafter, the
Yes.
administration have prepared an appeal challenging that order of the honorable single judge. That
Yes.
appeal is pending. It has to be.
No, but what is
Oh.
the relationship between formation of committee and this matter?
This is for conversion of land. That issue was conversion of land only.
Yes, what do you have to say to that?
My lord, one land use committee has been constituted, but that land use committee was never been functional. Even in another writ petition which is pending before this honorable court also, today's list was there, that MOUSHUMI, in that matter also similar issue was there. And
What is a similar issue?
similar issue, I have applied for diversion of my land, it was kept pending. I moved in writ petition before this honorable court. This honorable court directed the subdivision officer to consider my application.
Yes,
They have rejected in one ground that land use committee does not permit me to issue diversion.
yes,
So that order I have challenged, and that order was again quashed by this honorable court and directed the authority to consider my application once again and recommend my case to the land use committee for approval. And that point of time, there was no land use committee also. In my case, that land use committee has been constituted in that case. And thereafter, somebody challenged that constitution of land use committee that was quashed by this honorable court.
Yes.
Now, once it has been quashed, land use committee is not there. In view of rule A of the rule 1968, the subdivisional officer empowered to divert the land. There was specific law is there.
no, Mr. Sivalan, I don't see any connection between the appeals and this, all right? I will simply ask you to dispose of the representation within 7 days, because that has been pending since a long time. And till that representation, till maybe 2 weeks after date of disposal, there shall be a stay of this show cause,
Obliged, madam.
all right?
Obliged, madam.
The petitioner prays for a direction on the respondents / deputy commissioner, subdivisional SDO and the Tehsildar, South Andaman, to consider an application made by the petitioner for diversion of land on 20th January 2022. One minute. And what does this mean? Within a time frame change of land dated 7/4/24. What does this mean, Mr. Sivalan? Yes, you, Mr. Haldar.
And my prayer, my lord.
Yes, pray.
Prayer, within a time frame, my application be disposed of that diversion of land.
And also, stop. The petitioner also prays for stay of an order passed by the Tehsildar, Ferrarganj on 22nd December 2023. We are finding that the construction activity undertaken by the petitioner is in violation of section 151 within brackets 1 within brackets small b of the Andaman Nicobar Islands Land Revenue and Land Reforms Regulations, 1966. Now, what did I say? Whereby it was found. What did I say? Whereby? No, with a direction. Just delete what I had said. With a direction on the petitioner to stop the construction activities with immediate effect. Stop. Next. It appears from the submissions made on behalf of the parties that the petitioner is admittedly the recorded tenant of two.
Page number 17, my lord.
What is it called? Two what?
Recorded tenant of
Two-
land bearing survey number.
Two areas of land bearing survey numbers 93 and 94. Stop. The petitioner applied before the in the prescribed format under the, what is Rule 4A?
Rule 4A
Yes.
of Andaman Nicobar Islands.
Yes,
Land
under Rules 4A, under Rule 4A of the 1966 regulations.
No, my lord, Rule 1968.
Rule 4A of the Rules of 1968, within brackets, Andaman.
Andaman Nicobar Island Land Revenue Land Reforms Rules 1968.
Yes, close brackets. For permitting the petitioner to divert the land for the purpose of making a residential, for the purpose of making a construction for residential purposes. Stop. The authorities / subdivisional officer, comma, South Andaman, comma, however, sat over this representation and kept silent from and remained silent from 21/2022 till 22/12/2023. That is almost for 2 years. Stop. The Tehsildar, Ferrarganj proceeded to pass the impugned stay order dated 22/12/2023, directing the petitioner to immediately stop construction activities on the site on the ground of the construction being allegedly in violation of the Andaman and Nicobar Land Reforms Regulation, 1966. Stop. Next. The report of the Assistant Commissioner, South Andaman, records the application made by the petitioner and admits that all diversion cases, including the case of the petitioner, have been kept pending for finalization of policy decision. For finalization of policy decision within quotation marks. Stop. The report finds that the petitioner has illegally diverted the land by constructing the building. By constructing a building. Stop. Next. On considering the facts brought to the notice of the court, the court is of the view that the impugned stay order cannot be sustained that the impugned stay order for stopping that the impugned stay order issued to the petitioner for stopping the construction activities cannot be sustained when the authorities chose to remain quiet for almost 2 years without disposing of the petitioner's representation. Stop. This fact has also been duly admitted in the report filed by the authorities on 30th January 2024. Stop. The authorities should have first disposed of the representation, giving clear reasons as to the alleged illegal nature of the construction, and only thereafter proceeded to take necessary steps upon giving an opportunity to the petitioner to present her case. Stop. In the absence of the aforesaid comma, the stay order must be interfered with. Stop. Next, WPA 47 of 2024 is accordingly disposed of with a direction on the authorities / respondents to consider and dispose of the petitioner's application dated 20/1/2022 within a period of, Mr. Sivabalan, within a period of 6 weeks from today. Stop. The stay order dated 22/12/2023 shall remain. The stay order within quotation marks dated 22/12/2023 shall remain stayed until 4 weeks from the date on which the decision of the authority on the representation made by the petitioner is communicated to the petitioner. Stop. Next, that is all. Yes.
Item number 8, WPS 77 of 2024.
My lord, let it be next circuit bench. I am waiting for the service confirmation report in respect to respondent number 1.
Learned counsel appearing for the petitioner raised that the matter be placed before the next circuit bench as the service of the on the ground that the respondents have not been served till date. Stop. Next.
Item number 9, WP 83 of 2024.
And for the repetition now.
Yes.
But in connection with an area of below 50 square meter of a land, I have raised a building by obtaining sanction plan from the Port Blair Municipal Council, but under the law, plan is not required. It's beyond 50, plan is required.
What? I can't understand what.
So I have constructed a building within an area of 50 square meter.
Yes.
Under the rules prevailing here, Lordship, no plan is required up till 50 square meter of land. It's beyond 50, plan needs to be obtained. Even when I've obtained it, I've raised my building. The authority have passed the order for demolition of it. This point was raised before the council while hearing was conducted. I filed my written notes. This was not considered.
What was not considered?
Considered
Clearly.
as regards, Lordship, that my building is within the authorized portion of the land.
Yes, where is the impugned order?
You are at page 53.
Yes. That's your representation, or that's the order?
It's the order which I have challenged here.
Yes, show me why you're challenging the order.
Lord, kindly come to the order. I'll just show. I have filed my written notes of argument, which is at page 49 and 50. This point was raised. I'll just show this written motion argument. It's a short note which was placed before the council.
Yes.
Well, I will just show the relevant portion. That this point was raised. Lord, up to page 50, second paragraph at the top. May I place this paragraph, Notion?
Yes.
Fact remains that the respondent herein by way of conveyance deed, sale deed dated 3/8/2015 transferred her interest was survey number 3073, measuring area 322 square meter at village South Point under Port Blair Tehsil, along with the building to her three daughters, namely K. Nirmala, Srimati B. Vijay Kumari and Srimati K. Nagamani to the extent of 50 square meter each out of total area of 3073. Respondents, three daughters are having an area of 50 square meter each under their possession over which all three buildings are standing. As for back in the year 1991, that is on 23/1/1991, the respondent obtained sanctioned building from the council, erstwhile Port Blair Municipal Board for the entire land over which three buildings were raised and constructed. Even otherwise, under law, there is no requirement of obtaining sanctioned building plan for an area below 50 square meter. Photostat copy of the sanctioned building plan, wide approval number so and so, and sale deed date and so and so are enclosed here. This point was urged before the council. The authority passes an order impugn directing demolition of the building. This is first ground. Secondly, my lord.
No, what is it? The complainant hearing without any basis approached the writ court by filing. What does this mean?
Lordship, there was a writ petition being filed by an adjacent plot holder, based on which, Lordship, the council was directed to take a decision. I'll show that order. It's at page 42.
I don't understand your submissions. What is the point in law as to why the order should go?
Lordship, the structure which is standing
Yes.
cannot be demolished. For the sole reason, there is a building plan granted by the council. It's part of the writ application. This was shown to the authority. That's it. So according to the plan, no demolition can be effected. Even when
It was said that the plan is not required.
it's not required, but I have obtained it, Lordship. My mother have obtained it. My mother have obtained from the council. It's, Lordship, one who wants to raise building within 50 square meter, no plan is required. Apply can be made. It was done. It was granted. But this fact,
Show me the order which is subject matter of challenge.
Lordship, it's at page 50.
No, that I've seen. Which part?
I'll just show you. Page 54, last but third paragraph, Lordship. Now, therefore, in exercise of power conferred under me on the section 168A of Andaman and Nicobar Islands Municipal Regulation 1994, read with clause 32.8 of building bylaws, and as per the delegations of power empowered by the Secretary, Port Blair Municipal Council, wide number so and so, I hereby order and require your agents that the unauthorized construction.
Yes, I've read that, but why is this illegal?
Lordship, this cannot be sustained for the reason that there is a sanction plan which is, I have annexed it, Lordship, in the writ application. But kindly turn to the sanction building plan.
No, but what does the order say about it?
Lordship, they say nothing. They say that even then we have accorded the sanction plan, it needs to be demolished. This can't be done, Lordship.
Where does it say about the sanction plan?
My lord, just 1 second.
You're never ready in your matters, Mr.
Lord, page 53, last paragraph. Page 53, last paragraph. My mother's name has been recorded, whereas page
Yes.
Srimati Krupabai constructed a building after obtaining approval from the erstwhile municipal board, wide approval number 962, dated 23/1/1991, and we're being residing along with her family. So this fact was placed before the council, that since the sanction plan is accorded, kindly don't order for demolition.
Obtaining approval. Does it talk about sanction plan?
Sanction plan, this is a letter I'll just show, Lordship, along with the writ application. It's at page, my lord, 35. We place the plan for the according for approval. This was granted. 35.
Yes.
Now I would find at page 36, being the continuous of page 35, at the top right hand side, Malad would find the same approval number, which Malad would find in the impugn order. At page 53, last paragraph, same numbers, 962, dated 23/1/1991, same approval. Despite ignoring these documents, the past demolition order, Lordship.
Yes, Mr. Sivabalan.
My lord, this writ petition is not maintainable as being there is a appellate authority of the order of the secretary. The appellate authority is deputy commissioner. They, as per regulation, municipal regulation, they have
You
to.
show me the order, the authority concerned is superintending engineer at page 54.
Yes, your lords.
Yes. So show me the rules. Mr. Sivabalu,
My
you
lord.
must be ready. You're making a submission that is not
Right.
maintainable.
My lord. There is a.
How many pages do you have to search?
My lord, one second. Is there, my lord, I have just. Bylaws.
Learned counsel appearing for the prosecution, learned counsel appearing for the respondents shall get ready in the matter and shall get ready in the matter tomorrow. Stop. List this matter tomorrow. Next.
Copy me now.
Matter number 10.
Oblige, my lord.
Well, in this matter, I am appearing for the petitioner. Service was affected, my lord, but nobody is appearing in this matter.
Affected when?
On second, my lord, because out of three, two were served by hand, my lord. And the respondent number three was,
Show me the affidavit services.
I have
Yes.
filed it, my lord. With regard to service,
Yes, show me that they have received.
my lord will find first annexure, my lord, by hand it was given to respondent number two and three, my lord. And for respondent number one, it was sent through speed post, my lord. And it was delivered on 2nd of February 2024, my lord.
And they are, he's based where? The respondent number three?
Three is, I'm sorry, my lord, yes, Calcutta, my lord.
Calcutta says bamboo flat.
No, my lord, respondent number, I am just.
What are you saying?
Respondent number one, my lord, I'm sorry. Respondent number one,
Yes, so delivered by hand to respondent number one.
delivered by speed post to respondent number one and two and three by hand. Two and three are within Port Blair, South Andaman, my lord.
Yes, and delivered by speed post on second.
Second, my lord, that is on Friday, my lord.
What is the interim order you want?
My lord, it was.
Or you don't want an interim order?
My lord, on the last occasion, my lord has, an ad interim was rejected by this court, my lord. Kindly have.
The technical commercial bid.
My lord,
So what do you want to do, Mr. Kumar?
my lord, I will take a chance, my lord, once again, I will, my lord, please. Because on second only they have received it on Friday, my lord. Today,
Come back tomorrow then?
my lord.
Yes, no one appears for any of the three respondents. Stop. The affidavit of service shows that the respondent numbers two and three, comma, who are based in Andamans, were served by hand. And the respondent number one was served by speed post and received the same on 2nd February 2024. Stop. Next, list this matter tomorrow. Stop. The petitioner shall communicate this order on the respondents in the course of the day.
My lord, but respondent number one is in Calcutta, my lord. So,
Can appear virtually. Very well. List this matter on 7th February 2024.
my lord.
Next.
Item number 11.
May it please, your lordship. This is my
This
application.
matter may be taken
Substantially heard.
tomorrow, my lord, because
No, not tomorrow. You have to do it today. I'm sorry. Can't do it tomorrow.
I'm taking medicines after lunch. I have not taken my lunch. I'm bypass surgery.
Why have you not taken your lunch?
There was no time left. My
Well, 15 minutes. In fact, I sat after almost 25 minutes.
I was given the time that by 12:30, my lord will take.
This is not fair. You expect the court to pass an order and you're continuously taking time. This is not fair.
Well, my lord, may be taken up. May be taken up. I'll be here.
Very well. You make your submissions tomorrow. Mr. Kabir, I had some questions.
My lord.
ওই নোটটা দাও, আমার নোটস গুলো। ওনার নোটটা কোথায়? কবিরের নোট, নোটটা দিতে বললাম তো।
My lord, on behalf of victim, I am appearing.
Yes, Mr. Kabir, one, yes, some questions you please answer. All right, you can write down and then answer. One is, section 53A, that doesn't mention any time limits.
My lord,
Just says the power of the court, what it can do in a case of rape.
my lord.
Next is, what is the stage now? According to you, you're saying that post that Malviya case, that changed whatever Rita Nag, etc. You're saying now additional evidence may be called for, but only till the date of framing of charges, not beyond that. That is what you're saying?
No. I'm saying that further investigation could happen up to the charge was framed.
Yes,
From the time the charge is framed and trial starts, the court has a power to call for any person to ask for any questions.
yes,
It's not exactly additional evidence, it is to call for anyone.
yes,
That is 311 CRPC.
yes,
That mandates oral evidence, oral material within the knowledge of someone. That
yes,
continues up to the trial.
yes,
After the trial at the appellate stage, there's a different provision for calling for evidence again. That is additional evidence.
yes.
My submission is here, what the court has directed is a further investigation.
Very well. So what is not clear
My
from
lord.
your note is, you have just made your submissions, but what is not clear is when, according to you, you're saying that from the filing of from the FIR, the investigation started. That is what you have said. But you have not made it clear that according to you, when will that stage end? I am assuming it's till framing of the
Framing of
charges.
the charge.
All right, and then after that, the trial starts.
My lord.
All right. So what are the stages? What are the different stages according to you? Investigation, trial, etc. What are those different stages? Those have not been segregated.
I'll clarify that, my lord.
All right. And
If your lordship would just see E and F.
Malviya talks of cognizance of offense. But your note is not on any cognizance. Your note is on just framing of charges, then trial starts. Therefore, this 53A could not have been invoked after cross-examination is over. All that is what you have said. Yes.
Just to clarify, first of all, if your lordship sees my note at point E and F,
Yes.
these perhaps answer the question that whatever powers were there from the FIR during the phase of investigation, that could be exercised up till the trial started with framing of charge.
Yes.
So this I'll clarify further in a subsequent note if necessary. But the point here is what Malviya is talking about, the change is exactly this. The law used to be that as soon as cognizance was taken of the charge sheet, it was deemed that the investigation is completed. So the law earlier was a magistrate would not order further investigation after cognizance.
Yes.
That is what Malviya changed by saying after cognizance also trial hasn't started. Trial starts only when the charge is
That point is not very clear, Mr. How Malviya helps you, that is not very clear. Malviya just extends that time.
Malviya is saying specifically that the powers for further investigation can be exercised only until the charge is framed.
Yes.
That is the simple proposition of law which I'm relying on.
Yes.
So here, once the charge was framed, he doesn't have that power. I'll clarify this tomorrow.
And according to you, 53, or rather from a reading of 53A, that can be invoked at any time. Doesn't say that it cannot be invoked after this stage, that stage.
I will just have a look at 53A for a moment, madam. (53A), first of all,
Yes.
comes within chapter 5, which deals with arrest of persons.
Yes.
It is the procedure to be followed after the immediate arrest of a person.
Yes,
So once this person was arrested, at that point of time, 53A would have had an application.
yes,
Point number two, 53A, if your lordship would see subclause 5,
yes,
the registered medical practitioner shall, without delay, forward the report to the investigating officer, who shall forward it to the magistrate referred to in section 173 as part of the documents referred to in clause A of subsection 5 of that section.
yes,
173 is a charge sheet.
yes,
So essentially, 53A is when a person is arrested, he is examined. Immediately, that report has to be given to the investigating officer. It is part of the investigative papers and it is to be forwarded to the magistrate under 173 along with the charge sheet. All of this pertains to the investigative phase of trial of the proceeding. 53A cannot be read in isolation as a provision for examination. It is part of a certain setup, a certain matrix in which the law operates. That matrix has distinct stages. So here, when a person is arrested, 53A says you must get him examined and the report accompanies the charge sheet. In a situation here, where the investigation is long closed, arrest has happened long back and he's on bail, the question of 53A doesn't arise at all. The magistrate, the mistake that is happening here is two things. Number one, he is saying that 53A is allowing me to draw power to direct this examination. This is no power of the court. This is part of the arrest procedure as part of Chapter 5. The court cannot later on say that I am invoking 53A to direct such an investigation to be done. That does not give powers to.
and the court has also come to a conclusion that there is no prejudice faced by you because you will be given the opportunity of questioning and all that.
With the greatest of respect, the prejudice is that once I have started and opened my defense, there cannot be an attempt to fill action. That is a prejudice which is immeasurable. That is why the courts have always said that after the charge is framed, there cannot be a further investigation. Now, kindly envisage a situation that a trial starts, the prosecution has certain lacuna, and the court says, well, this is a case where I feel you should be convicted, so I'm directing the IO to go and fill up all these blanks. This cannot be done. It's not part of criminal jurisprudence.
Very well. Yes, what do you have to say, Ms. Mini?
For the victim,
Yes, Mr. Mohammed, then what, tomorrow? Yes, and tomorrow, Mr. Kabir, please close your submissions, all right?
I have completed. I can just submit this note and.
Yes. And 5 minutes to you tomorrow, Mr. Mohammed, but just 5 minutes, please.
appearance है क्या victim का? Victim.
But in case I am not there, my learned junior would be there. He would submit the notes and
Well,
address your options.
yes. Learned, the learned PP seeks an adjournment. Stop next. Upon hearing learned counsel appearing for the petitioner has clarified some points. Clarified few of the points raised by the court. Stop next. List this matter tomorrow.
Clarified for the court's satisfaction.
I'm not sure. I will say that tomorrow.
Madam.
Lord, I think the victim has to be present today. That's why I filed my wakalat nominee.
Victim was present today.
There was some direction.
No, there is no direction for personal presence.
Absolutely not. Why should I direct the victim to be present? And Mr. Kabir, the other thing is that what is the issue? The issue is that that the medical examination that could not have been directed under 53A.
My lord.
So the order passed by the first court, the trial court, on the application made by the prosecution, that is what has aggrieved you.
Yes, ma'am. Primarily, that is, if that order goes, everything is back to normal. The trial proceeds as normal on merits.
Very well. And the charge is of what? Rape, 376.
POXO. So
POXO, yes, POXO. And the paternity, question of paternity was found to be relevant because there is no clarity on that point.
let me put it very simply. The reason for the paternity issue, there are two usually. One is on the civil side where things of inheritance, money, all that comes. Here, what is happening is if my cross-examination succeeds, the case collapses. At that point of time, the prosecution, if it waives a DNA report saying that the child is 50% mine, 50% the mother's,
then everything else goes. So this is an attempt to create something to fill up all the gaps which I have exposed in my course. Because if it, say for example, in the cross-examination, she is admitting she had an affair with me, she had an affair with others. Now tomorrow, if we go and get a positive report saying that the child has 50% of my genes, then they will say this is not proved irrecoverably that you had at some point of time relations with her which resulted in this child being born. Therefore, she's a minor, therefore consent is immaterial, therefore QED, you'll be convicted and go to jail for 10 years. This is the logic.
Very well. Yes, call on the next matter, please.
Deep privilege.
Item number 12. Please, 905.
I appeal for respondent.
My lord, I have already filed my reply. My lord, issue involved in this writ petition, my lord. I am the recorded tenant of particular landed property.
Microphone, please. Yes,
My lord,
yes.
I am the recorded tenant of land bearing survey number 145, area 600 square meters situated at Lambaline village. And this is the allotted land not allotted under section 146 subsection 2 of the regulation 1966. And this allotment,
Where is the order of 30th
lord,
January?
I have challenged.
Very well. Yes, yes. Yes, tell me your case, please.
Yes. Now, this land has not been allotted free of cost. The committee.
No, what is the prayer? What is the prayer in your writ petition?
Where I have applied for necessary document, no dues, non-inconvenience valuation certificate to transfer this property in our parent department, parent committee on the way of gift.
Our parent committee means?
This is recorded in the name of a committee, that is Ahmadiyya Mosque Committee,
Yes,
under the part and parcel of Sadar Anjuman Ahmadiyya, that
yes,
is at Punjab.
yes.
So there is a mosque. Mosque is in dilapidated condition. And the parent committee is willing to reconstruct the mosque. Subject to the condition, the land has to be transferred in the name of the parent committee.
Yes.
So I have applied for the necessary documents, no dues, no inconveniences and valuation certificate. I am ready to pay the registration charges also.
Yes.
Now, they have rejected my claim.
Yes.
They are asking the allotment order. The record has been filed.
Where is the rejection?
Yes, that page number 25 last. Application saying that to CSC citizen submit allotment order. There is no allotment order at all. And if there is any allotment order, that should be with the authority. Because why I am submitting, this land was encroached by the committee way back in the Japanese period, constructed a mosque. And thereafter, in view of scheme 1987, the pre-78 encroachment regulation scheme, the land has been allotted. And it is not allotted free of cost. License has been issued. I have enclosed the license.
So then you haven't, there is an allotment order.
There is no allotment order at all because
Just now you said land has been allotted free of cost.
allotted means the regularized.
Yes.
Regularized. As per the scheme regularized, I have been directed to pay the
Yes, Mr.
premium.
Roland, what is it?
Premium. I have paid the 60,000
Your
premium.
Lordship, in this island, there are Ahmadiyya community peoples are there. For them, this allotment, I have enclosed my allotment order, which is at page number 7A, license. In my reply, in my opposition, I have enclosed R2. This is the license issued in favor of Ahmadiyya Mosque Committee number N,
Page 7?
page 7A.
Yes. This is a license.
License.
Yes.
By way of license, it was kindly see clause 2, the license shall not use the land under the license granted to him for any other purpose other than construction of mosque building.
Yes.
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 So now you are trying to transfer this land to some other third party under the garb of saying that my parent committee is in Punjab, like that. But this has been allotted only for the Ahmadiyya Mosque Committee of for lumber land.
No, just reply to the contention that there is no allotment letter, that.
This is the license, this is the allotment or,
Last,
Yes.
this license is subject to the payment of premium of 60,000. I have included.
1 minute,
allowance.
please.
My lord.
You
Sorry.
will get your chance. So
No,
if
no.
this is a license, then according to there is a separate allotment order also.
no, my lord, this is the license and then.
That is what,
Under
that is
rule-
what that is what the impugned order says, submit allotment order. At page 25.
My lord, they were asking for this license only.
So
That
you
was-
have produced a license, so what
Yes.
remains? What are you saying?
They are asking for transfer of the land. That cannot be allowed because it has been used, allotted for a
Yes,
particular
but
person.
that says application sent back to CSC citizen, whatever that is, submit allotment order.
My lord, for submission of documents of.
Very good. So you have produced this document in these proceedings, so now what remains of the writ petition?
My lord,
Have you understood what I'm saying?
yes, ma'am.
You're saying that there is no allotment order, but there is a license.
Yes,
You have produced that license as part of your opposition.
yes.
Then now what remains of the writ petition?
No, their prayer is, may not be convincing. It's not that they want allotment order. There are,
No, that is not what they are wanting. You have said it. You have made it a requirement.
yes, ma'am.
They are saying to issue a no dues, non-encumbrance and valuable certificate. That is their prayer.
Yes, sir. Yes. For the purpose of transferring the land.
Yes.
Yes.
So you're saying, so what is, according to you, what do they have to do to get these documents?
This document cannot be given, my lord, simply for transfer of the this land. This land has been issued for the community purpose for Ahmadiyya Mosque Committee lumber land. They cannot use this land or transfer this land for any other purpose to another party. This is for a community purpose.
Yes, what do you have to say, Mr. Halder?
Nowhere it is written that it is community purpose.
Yes,
Even
for construction of mosque.
record of right, nowhere it is mentioned.
No.
Even in the license also. In the license also, there is no mentioning that it is for community purpose.
It is for construction of mosque building.
Mosque, I have constructed the mosque. Even they have asked me to pay the premium of rupees 60,000. I have paid.
Very well, Mr. Sivavalan, I am setting aside this order. Okay, I am quashing this order at page 24, at
My
page
lord.
25.
My lord.
Saying that there is, admittedly, there is no allotment order.
My lord.
The only document available is the license, copy of the license, which has already been brought to the
My lord.
notice of, which has been already brought to the records of the court.
My lord.
And that you will give the petitioner, and since you are proceeding on a basis that they are trying to alienate the land in favor of a third party,
My lord.
and that is not evident from the record.
No, it is, their application is there for gift permission, they are seeking this document.
There is.
Yes, their application. Where
This
is it?
page.
Yes. This application, their application for.
Yes,
Paragraph 7, page number 6.
that's all. That's your pleading. Show me the document, please.
This is page number 19P3. This is the declaration given by them. Para 2. For the purpose of registration of gift deed.
Yes, where be paragraph?
Para 2, annexure P3.
Yes.
Uh,
Where does it say that give deed to a third party?
This last line, this no use. The Ahmedabad Mosque
Yes,
Committee
yes,
is
but where does it say for a third party?
for gift deed. It is gift deed is for giving alienating. For registration of gift deed, they are required to this. These two documents are required.
Very well. The impugned order, which is under challenge, was passed by the, which authority passed this?
Subdivisional officer.
Where do I get that from? No,
This is not mentioned in the report.
just delete. The petitioner prays for a direction on the respondents to issue no dues and non-encumbrances certificates in respect of a land situated at Port Blair, Tehsil, recorded in the name of the petitioner committee. Stop. The petitioner requires these documents for the purpose of registration of a gift deed, which would appear from a self-declaration for no dues and non-encumbrance and valuation certificate given on behalf of made on behalf of the Ahmadiyya Muslim community on 6/4/2023. Stop. Next, learned counsel appearing for the petitioner submits that the petitioner had made an application to where? To the
Online submission.
had made an application online before the concerned authority for issuance of no dues and non-encumbrance certificate to the Ahmadiyya Mosque Committee. It will be committee, not community. Committee, but that the same was rejected, but that the application was rejected on 13/6/2023, directing the petitioner to submit the allotment order of the said land. Stop. Council submits that the land was regularized in the name of the Ahmadiyya Mosque Committee way back in 1992 without a formal order of allotment. Stop.
Under the scheme of 1987.
Under the scheme, what scheme?
Regularization scheme of 1987.
Under the regularization scheme of 1987. Stop. Next. This submission appears to be correct in view of a document enclosed in the affidavit in opposition filed by the respondents in Form AG-3, which is a license to occupy, quotation marks, which is a license, quotation marks, license to occupy land for non-agricultural purpose, close brackets, close quotation marks. Stop. Clause 2 of the license stipulates that the licensee, within brackets, the petitioner herein, close brackets, shall not use the land under license granted to him for any purpose other than construction of mosque building. Stop. Next, learned counsel appearing for the respondent submits that there is that the license to occupy was the only document given to the petitioner at the relevant point of time and that there is no allotment letter. Stop. This position is sufficient for the court to quash the communication at Annexure P6 of the writ petition, whereby the authority concerned has directed the petitioner to submit an allotment letter and has sent back the petitioner's application for no dues and non-encumbrance certificate on that basis alone. Stop. Next, since there appears to be several subsequent facts which are not on record, including of the allegation that the petitioner is trying to alienate the land in favor of a third party, and the petitioner denying the said allegation, comma, this court is of the view that the respondent authorities namely the deputy commissioner slash deputy commissioner, including the deputy commissioner, should give an opportunity of hearing to the petitioner in respect of the petitioner's request for a no dues and non-incumbency certificate for the purpose for which the petitioner seeks those documents. Stop. Next, who will give that hearing, Mrs. Sivabalan?
My lord, respondent number,
Let it be respondent number 1, Deputy Commissioner.
WPA 915 of 2023 is disposed of with, is accordingly disposed of with a direction on the respondent number 1 to give an opportunity of hearing to the petitioner and consider the petitioner's request for the documents forming part of prayer I of the writ petition for the purpose for which the documents have been, for the purpose for which the documents are required. Stop. The respondent number 1 shall give a reasoned, pass a reasoned decision pursuant to such opportunity of hearing within 6 weeks from the date on which the petitioners are last, a petitioner is last heard. Stop.
obliged, my lord. My lord, in that, I request, my lord, my application for waiving the cost. In this case, this.
Have you paid the cost or not?
No, my lord, I have filed application, request for waiving the cost. Since we have filed our opposition.
What was the order taken? Where is that order? Order dated?
First February.
First February. First February, there is no such order.
31st, my lord, on the first date of hearing.
Don't know which that was.
My lord,
You made an application, you don't even know when that order was passed.
yes, my lord, I don't. Let me take. January 30th.
Why do you want that order to be waived?
My lord, I have already filed my opposition. Because I have not filed my opposition, this honorable court has imposed me cost.
Very well. Learned counsel appearing for the respondents persuades the court to recall the order dated 30th January 2024, whereby the respondents were directed to pay costs to the SLSA, AMN Islands. Stop. Since the respondents' affidavit in opposition was filed on that date itself or
Next
not?
date.
On the next day, the order dated 30th January 2024 is recalled. Stop. What is your application number?
Number 1 of.
Plan 1 of 2024 is disposed of in terms of the order.
Obliged, my lord.
Next.
Number 13, W 942 of 2023.
I pay for respondent, my lord.
The lordship kindly fix on tomorrow, Your Honor.
Who are you?
Mr. Sabir is appearing in this matter, Your Honor. He's not well, so kindly.
Who are you appearing for?
I for the petitioner in this.
So you and the respondents will stand on the same microphone and argue? Yes, sir, list this matter tomorrow as prayed for on behalf of the petitioner. Next.
Number 14.
My lords, in
979 of 2023.
in 14 and 15, my lords, I'm appearing for the respondent. I'm praying for time to file a supplementary affidavit. My lord.
Well,
Because my lords, affidavit in opposition, my lord, there is some, find it is deficient, my lords.
do you file your opposition?
Opposition and reply is complete, my lords. It's, this year only it was completed, I think.
Circuit.
Yes.
But why do you want to file a supplementary affidavit, Mr.
My lords,
Chaudhary?
because my lords, while preparing the matter, my lords, I realized that my lords in the affidavit in opposition, my lords, we have not addressed, my lords, because the question is of 1/30. And my lords, these petitioners, we have said they do not meet the criteria under the 10th August 2023 circular. But my lords, we have not really explained why they do not meet the criteria, my lords. So merely saying that they don't meet the criteria, my lords, is not a. That's an answer.
1/30 is that forest workers or something?
This is not that, this is not for, this is municipality, my lords, but my lords had heard similar matters in connection with tourism department, if I recall correctly. This is also at a travel to the.
And those writ petitions had been disposed of?
Yes,
My lord had granted
disposed
relief
of,
in the.
and thereafter the division bench was affirmed the order of this court.
But this, my lords, is also connected in a sense to the water pending in the Supreme Court arising out of.
No, nothing, my
No,
lord.
they have annexed all. My lords, they.
Very well, supplementary affidavit by day after, at best, Mr. Chakraborty. When did you file your opposition?
I received it on 16th of January, my lord.
16 January?
January, my lord.
Then why do you want a supplementary affidavit in
And my
February?
lord, that too, my lord, after the extension given by the court, and the court has directed them to file, otherwise they will not get an opportunity. Thereafter, they have
Mr.
filed it.
Chakraborty,
And my lord will find here the case is, my lord, the case is that juniors got the said benefit, seniors have not got. Our specific case is that these persons who are junior to us, they got the said benefit. They simply
it said benefit, what?
the benefit of the 1/30th of plus DNS allowances, because they all are daily rated employee. Now, my lord, this is our specific case, my lord, and they, with 2-line affidavit, my lord, they said that you are not entitled. There is a specific allegation that juniors got, all the documents we have enclosed.
That takes, my lord, there are certain file notings I wanted to place, I will place it, my lord, I will not.
Very well, yes,
Place it without affidavit.
yes. Mr. Kumar, you start your submissions, please.
My lord.
And show me that order which was passed earlier, which you said was affirmed by the division bench and all that.
My lord, that my lord, these petitioners, my lord, they are working under this autonomous
What
body.
is that order? I can read it, it will be faster, quicker.
My lord, that order, my lord, it was within the division bench file, my lord. My clerk has taken that division bench was over, my lord. That was affirmed by the bench presided over by my lord Justice Soman Sen, my lord.
You have said that once before, but I needed to read that order.
No, absolutely, my lord. And in that case, my lord has dealt with all the other judgments wherein I appeared for the petitioner, my lord, and the matter went up to Supreme Court and the Supreme Court has not interfered. All those judgments, my lord has referred, my lord.
There the issue was different. There the question was where the date from which the benefit is to be given. Here, my lord, the administration is saying that they are not entitled to the benefit because the nature of the work is seasonal, etc. And my lords, they are relying upon a circular which is issued after the Supreme Court's order in the recent, my lords, matter arising out of APWD, where my lords, certain strictures were passed by the division bench and content, my lords, certain directions were passed against the chief secretary and the lieutenant governor. And then that went up to the Supreme Court, my lords, an additional affidavit was filed, and in those proceedings, my lord, pursuant to the orders, my lords, a notification was brought out on 10th of August 2023, whereunder all those daily rated Mazdoors who were not given the benefit under the earlier circulars, they were given the benefit of 1/30. But the only criteria that there is that forest is excluded and they should not be, their work should not be seasonal in nature. Pursuant to that, an exercise was carried out by the municipality, which is covered under the circular, otherwise being an autonomous body of the administration, wherein around 600 odd people were given the benefit. But the benefit was denied to these petitioners, my lords, and as per the file notice, my lords, it appears to be on the ground that they are doing seasonal nature of work and they are mustered roll. There is no, they are not doing regular nature of work, because under the the Genesis 7th of June 1988 circular, my lords, the basic principle is they have to do work of regular nature. So my lords, on that basis, my lords, the benefit has been denied to them, my lords. This is not on the question of the date from which the benefit is to be given, etc. It's a factual, my lords, issue.
Very well. You, I will hear it. You can
My lord.
place a file notice
My-
tomorrow. All right.
But tomorrow, my lords, I'm 8th, my lords.
Very well. This is matter on 8th February 2024 as paid for on behalf of the respondent.
My lords.
Next.
Item number 16, WPF 1027 of 2023.
I'm for the respondent.
Your Lordship, the petitioner, Mr. Sabir is appearing on this matter, you know, please not also kindly fix on tomorrow. Yeah. Post this much.
You offered who, Mr. Jaipal?
Respondent two.
I am for
You just made up your mind where to stand.
I'm so sorry. I'm so sorry. It's my mistake.
Yes,
I'm so sorry.
yes, list is matter tomorrow as paid for on behalf of the petition. Next.
Achha.
Number 17, WPF 13 of 2024.
I am occupying a subject land ownership since long. But the authority have right to evict me by setting the appropriate proceeding motion. That they are not doing. Because under the local regulation, 202 is the power vested with the Tahsildar to initiate a proceeding. Once that is done, I can file a suit establishing my right over the land. I am there for more than 3 decades, my lordship. I have my right.
What is the prayer?
No, so my prayer is I should not be evicted without due process of law.
No, have you not challenged any order?
No, order has been, it is without due process of law.
Then why you filed the writ petition?
They have given a threat of dispossession, my lordship. The Tahsildar,
Where is that threat?
I have given a pleading, my lordship, to that extent.
Pleading.
Pleading is there, my lordship. No threat, my lordship, they do not initiate any proceeding. Simply Tahsildar enter into my premises, threat has been given.
What is this?
My lord, as per instruction, this is a government revenue land and as per the demand of the public, the government is setting apart the land for the purpose of playground.
Yes. Playground.
Yes.
And who is the petitioner?
I'm occupying there, I'm carrying out cultivation work, my lordship. I'm an encroacher, I do it.
Petitioner is having no right in the land property since the land belongs to the government revenue land. As such, the writ application itself is not maintainable.
No, who is this Satyaban Paul? What is he doing? He is occupying what land?
It's a government revenue land he has encroached. He is
No,
a
but is
encroacher.
it correct that you are trying to evict him?
My lord, that is, it is true that the land is.
No, there is some representation which you have spoken about. What is this, 13th November?
It's, I have made to the authorities concerned, my lordship.
Where is that?
At page 21, my lord, annexure P2. When the threat was administered, I approached the superior officers to the Tahsildar. This was kept pending.
Page number?
Page number 21, annexure P2, my lord.
Yes, and have they replied to this?
Nothing, my lordship. They're sitting right over the matter.
Where will you respond to this?
My lord.
Until you respond, don't take any steps.
My lord.
And what is the time within which you will respond?
My lord, 8 weeks.
8 weeks.
My lord.
You don't want to take any steps for 8 weeks. The petitioner prays for a direction on the respondent authorities not to take. Now, the petitioner prays for a restraint on the respondent authorities not to evict the petitioner from the land without due process of law. Stop. Although the writ petition does not disclose any document expressing, articulating such threat of eviction or otherwise, learned counsel appearing for the petitioner submits that the Tahsildar, which South Andaman, that the Tahsildar, Diglipur, is bent, B-E-N-T, bent on initiating proceedings, is bent on evicting the petitioner without giving an opportunity to the petitioner to reinforce to prove his right to remain on the land in question. Stop. Next, learned counsel appearing for the respondent submits that the land in question belongs to the revenue authorities. Is that what you said?
Government revenue land.
Belongs to the government revenue department and that the petitioner has illegally encroached on the said land. Stop. Next, it however appears from the documents brought on record that the petitioner had made a representation to the Assistant Commissioner, Diglipur on 14/11/2023, praying for the intervention of the Assistant Commissioner with regard to the government revenue land, which the petitioner has occupied for more than 30 years. Stop. Admittedly, the Assistant Commissioner / respondent number 3 has not replied to this representation. Stop. Hence, considering the balancing equities, hence considering the balance of equities and due process and the need to adhere to due process before taking any steps against a petitioner for eviction or otherwise, this court is of the view that the respondent number 3 should first respond to the representation before any action of eviction is taken against the petitioner. Stop. Next, WPA 13/2024 is accordingly disposed of with a direction on the respondent number 3 to dispose of the representation within 8 weeks from today, as per suggestion made on behalf of the respondents, made on behalf of the respondents. Stop. The respondent authorities shall not take any action against the petitioner in the form of eviction or any other penal measures till 3 weeks after the petitioner receives communication of the reasoned order taken by the respondent number 3. Stop. The respondent number 3 shall give an opportunity of hearing to the petitioner before arriving at the reasoned decision. Stop.
I'm deeply obliged.
Obliged, my lord.
Next.
Third same matter.
Item 14, WPA 14/2024.
Same order, my lordship.
Same date also?
Same.
Same order. Next.
Obliged, lordship.
I'm grateful.
Item 19, DPL 60/2023.
No, 14 and then 19.
Oh, no, that was 18 minus. Mistakenly said 14.
No, कोणता बोला same order. 17 and 18 same order. Very well. Yes.
And this, my lords, on the last occasion, my lord, I had placed the order. It has been complied with, my lords, although there's been some delay in compliance. But they had sought to withdraw. But my lord, since I think the main council was not there, so my lord had kept it for today.
Main council?
Mane, the
The last one.
petitioner's advocate was not, the junior counsel had appeared. So at his request, it was adjourned.
So this is the compliance, 23rd January.
Yes, ma'am. The direction was to dispose of the representative. That has been done.
Where is the order in contempt?
Lords, because the first time my lords, 23rd, its order is set out, my lords, on the first page. But the contempt petition, my lords, which is not served on us because it's should have the order, my lord. Order for compliance.
So this was disposed of when?
Order, your lordship's order was on
No, no,
24th
no,
November
the order
22.
in contempt.
24th November 22.
And this was disposed of when?
My lord,
Disposed of by the order dated 23rd January?
yes, my lord, yes, ma'am.
Yes, no one appears for the petitioner. Stop. The respondent, learned counsel appearing for the alleged contemnor, had submitted on the last occasion, i.e. on 31st January 2024, that the alleged contemnor had already complied with the direction contained in the order in contempt dated 24th November 2022. Stop. Next, this would be evident from the order passed by the, by the order in contempt, comma, the Deputy Commissioner, comma, South Andaman District had been directed to dispose of a representation made by the petitioner. Stop. Next, the order dated 23rd January 2024, comma, placed before the court shows that the representation was disposed of by this order, i.e. the order dated 23rd January 2024. Stop. Hence, next, hence nothing remains of the contempt proceedings. Stop. CPAN 60 of 2023. Nothing remains of the contempt proceedings in view of such compliance. Stop. Next, CPAN 60 of 2023 is accordingly disposed of in terms of the above. Next.
भैया का नहीं नाम नहीं है, ये वाला होगा. Same order, my lords, 20 and 21.
Item 20, CPL 16 of 2023.
Dates of the order same?
Same, sir.
Yes, same order. Next.
Item 31, CPL 16 of 2023.
Same order? Or is it different?
Same order, same order.
Same order?
Yes, ma'am.
Same order. Dates also same, Mr.
Yes,
Chaudhary?
ma'am. Disposal order is.
Yes, next.
Item number 22, CPL 7 of 2024.
Yes. I can't hear you. Yes. Received it?
Lord, I have received the compliance report, but this is with regard to electricity. The petitioner has given the wrong survey number. Actually, the survey number which the,
When is the order in contempt?
it's at page, my lord.
You're making submissions without even telling me which where the order of contempt
The
is.
order is passed by Justice Harish Tandon.
When he is available, how can this lie within? Yes, say that first. You are going into the merits.
Ma'am.
The order in contempt is of 20th September 2023. Stop. Since the honorable judge, comma, who passed the order, comma, is available as on date, comma. CPAN 7 of 2024 is released from my list and should be placed before the Honorable the Chief Justice for assignment. And should be placed before the appropriate bench. Is released from my list and should be placed before the appropriate bench.
Okay.
Next.
Item 23, 85 of 2023.
My lord, I am appealing for the petition, my lord. This application was filed for appointment of arbitrator, my lord.
Section 11.
My lord, section.
Are you opposing, Mr. Chakraborty?
Filed our affidavit of opposition.
And what about reply? Complete.
Yes, my lord, complete.
Very well. I will take it up tomorrow or not though? Day after tomorrow?
My lord.
Yes. This is matter, you're opposing appointment of an arbitrator.
Eight. That's my lord.
Eighth, you're opposing appointment of an arbitrator.
We have raised the point that it is covered by an earlier arbitration, but that's.
Mr. Kumar, just give me a one pager on eighth as to what the dispute is.
My lord,
All right, just
Well-
one page
my lord,
as to what the dispute is. That is all. And just the page number of the arbitration clause
yes,
in the agreement. What is the agreement for? All right. And what is the valuation of your claim?
my lord.
Our point is that it was already decided in earlier arbitration, but my lord's point of res judicata also, my lord.
My lord, initially, for the purpose of procurement, certain materials were brought.
Mr. Kumar, you come back
Well,
on eighth.
well.
Right. Yes, this is matter on 8th February 2024. As straightforward on behalf of the respondents, that affidavits are complete in the matter. Next. I will take up till 26 today. Next.
Item number 24, WJ 96 of 2024.
None appears for the petition.
Mr. Kanan, filed by Mr. Kanan.
Well.
He is not available in court. When is he available?
Tomorrow.
Sorry?
Tomorrow.
Tomorrow. No one appears for the petitioner. This is matter tomorrow. Next.
Same, three matters.
Yes, same. And with a line, a learned counsel appearing for the Union of India, a learned counsel appearing for the respondent
Well.
will communicate this order on the petitioner in the course of the day. And Mr. Lal, please ensure that the petitioner is represented tomorrow.
Well.
Clear that if the petitioner remains unrepresented, the court will proceed to pass appropriate orders tomorrow.